Yes, Lordship.
interim Jima.
My lord, kindly take a note tomorrow, your lordship.
And tomorrow what do?
Yes, sir, 2023. 23 your lordship.
What are they?
2023 ପକେଇକି ରଖିଥିଲେ ଜଜମେଣ୍ଟ ଆସିଲା.
I'll take it. देखी रहोगे दिया. Yes.
I didn't mention my
Judgment, sir.
अच्छा judgment सब.
for judgment item 1.
The IA filed by the petitioner for condonation of delay in filing the review petition is rejected. As a consequence, reviewing petition is also dismissed.
Item 2.
Same here, the IA for condonation of delay is dismissed. As a consequence, the review petition is also dismissed.
Item 3.
The IA for condonation of delay in filing review petition is dismissed. Accordingly, the review petition is also dismissed.
Item 4.
Same here, the delay condonation application is rejected. Accordingly, the review is also dismissed.
Item 5.
I'm not inclined to entertain the petition at this stage. Accordingly, the RLM is dismissed.
Item 6.
The revision petition is allowed.
Obliged, my lord. Obliged.
Item 7.
The imbue notary is set aside, that the criminal MC is disposed of.
Item 8.
The imbue notary is set aside, and the criminal MC is allowed.
Item 9.
The opposite party number 7, 8, and 9 are directed to restore the custody of the child to the petitioners who are the biological parent, subject to the condition as enumerated above. In para 15, I have put some conditions, and I have dealt with all the legal issues for custody.
Item 10.
The review petition is dismissed.
Item 11.
The imbue notary is passed, and the petition is definitely good.
I want to make a mention, my lord. The 3 CRLMC applications arising out of family disputes. Matter settled. The matter is adjourned to 27. They have their date on 30. They are already in Bhubaneswar. If the matter could be taken up in the second half of 31.
31.
No, my lord. Out of the list, my lord.
Out of list today, I can't take it.
31, my lord, because the wife has to travel from Sambalpur to
Tomorrow.
tomorrow is their date in the family court, Bhubaneswar.
I can't take it up because today.
Not 31.
31st. So
31st.
My lord, out.
It is a settlement matter.
Settlement matter. 3 CLMC applications arising out of 2 affairs.
What are the offenses?
Of 490.
Okay. 31st.
My lord, arising out of EC case, my lord. The matter has already been settled between the parties. Both insurance and claimant, my lord.
What are the offenses?
Oh, no, my lord. The arising out of EC case, vacuum and compensation case. Vacuum and compensation.
You have settled. The FAO.
FAO.
FAO. Please see. Okay. But it will be listed tomorrow day after.
Listed yesterday, my lord. So one thing this says.
Yesterday's matter will be taken up within this coming week. Just adjust it. Give it.
I don't to make a mention, there is some typography mistake in that. Para 6 plus. That's the. That is instead of para 6 plus, you find this. Instead of the commissioner of police, it has been DSP lot. Para 6.
It should be commissioner.
Yes, let's say Bhubaneswar UPD, let's.
Mr. Satyapat Mamti mentioned the matter out of court, out of list, and submits that in para 6 of the order date 27/1/2025, there is a typo error. Instead of deputy commissioner of police, deputy superintendent of police has been mentioned in the para 6. The same stands corrected. Same stands corrected. Figure आप लोगों को, हाँ? Formal specialist.
Your Lordship, I'm mentioning CRLMC number 3909 and 3947 of 2024. It pertains to 143A interim compensation under the NIM. We have filed an extension, IA for extension of time because there was a endeavor, we were trying to set.
Direction given by this court.
Yes, Your Lordship, we are ready to pay 20% of the entire interim compensation. Your Lordship had directed us to pay 10.
Yes.
So in the meanwhile, the time had expired, within which we had to pay the 10% amount. We are ready to pay the 20% amount. We also have the DD with us. Kindly, if the matter
Are you
is
ready to pay
listed,
20% or 10%?
20%. We'll pay the entire 20% amount because there is already a settlement which is
Already
in
the-
progress. Yes, Your Lordship. So if it's.
Yes. I will record, but tomorrow I'll record when, if I'll take up the matter, I'll record that you are settling the dispute. Okay.
Yes, because we'll also provide the copy of the DD, as in the photocopy of the DD.
Yes.
After this mention. Can you mention the item number? 12 to 18. 19 to 28.
My lord, item number 22. They preferred SLP before the Honorable Apex Court. And the Apex Court and the CU.
Let it come, I'll just take it up. Yes, let it come.
29 to 35. 36 and 37. 38 to 44. 45 to 54. 55 to 66.
Lordship, item 58, they were an adjournment matter. Item 58.
Look, that's it.
66. Passport for the day. This is pertaining to that. Application they have filed for to be discussed. I'm ready, but let it pass because the order.
I'll accommodate you, don't worry. I'll accommodate you. Yes, I'll accommodate you. I'll just see. It's not a very big matter or small matter.
Small matter, but after lunch, that's I have to go down.
You be relaxed, no problem. After lunch, I am also sitting in full bench.
Larger bench.
So that's another problem. So it may not be taken. Okay. Yes.
Larger may continue
Larger
after.
bench is there.
Sadly, with huge.
It's always a pleasure work with you people.
Yes.
They demonstrate that there was confidence or not.
Yes. Item 12. We see no mention. Yes.
Item 12.
Madly. This matter settled between the parties. This is a case of 307. On the last occasion, my lord has directed my learned trade take instruction about the injuries.
Injuries, just see what are the injuries.
I'll
Because
take it.
326 is there.
Yes.
307.
307 is
Uh-huh.
also. I have to take instruction. Has.
Matter is settled that also.
No, settle, but
Yes.
kind of injury has to be taken. That's all.
Yes.
You just check it up.
One week after.
Okay, 1 week. Then counsel for the petitioner submits that the matter had already been settled between the parties. And on the basis of settlement terms, they want seeking quashing of the entire criminal prosecution against the petitioner. For the state submits that since since the offence under section 307 is involved in this case, he wants to seek instruction because the nature of injury sustained by the injured. Release the matter.
One thing I want to draw my lord's attention, that the victim in the meanwhile, case of 2008, he is no more. And
Injured is no more.
The wife was appeared before this court on that.
Now, injured is no more because of you or because
No.
No.
let him get it.
I am
That's instruction.
for the wife.
So see the
Yes.
injured witness has died.
No,
And the injured witness is otherwise died. So you won't get that evidence, which is very strong evidence for 307. And that is you won't get.
Yes.
So putting them to trial also is the futile.
Nothing. But the wife was present before this court on that.
Well, after, yes.
Item 30,
My lord.
So, okay.
40,
May I please? Let 40 OPID matter.
Okay.
Name of Mr. Bhuya may be indicated and a copy may be served on me, Lord.
Now Mr. Bhuya has become senior.
Along my name, along with his name, both.
Senior's name, in fact, should not be there in the cause list. Seniors keep on changing. Today you engage some senior, tomorrow you engage some other senior.
Yes, yes.
Why senior's name will be there in the cause list?
Because
we, sir will also agree to that.
yes.
Because today you engage Mr. Das.
No, I
Tomorrow
cannot.
someone else.
No, I
How many
cannot.
names you will keep
I
on?
can. He is already in this panel, my lord. OPID
There is
panel.
no one in panel now. He's senior advocate.
Senior, yes.
Senior advocates never be in any panel. So let it be like that.
Then
Let us have the-
my name be indicated, my lord.
Your name will be.
My lord.
His name will be.
I will serve the copy.
One copy may be served on me.
My lord, one thing I want to.
Senior's name don't write in the cause list. It's not
Miller.
fair for writing.
Yes.
It's not required. And whenever I have been telling, whenever a senior counsel is appearing, his name along with the briefing counsel name has to be there. How can a
Yes,
senior
yes.
counsel appear without
Independently
counsel?
cannot.
And
Independently
you
cannot.
see the
appear.
proceedings,
Yes.
many proceedings, only senior counsel name is there.
Yes.
That's not permissible.
Your lordship is right.
Senior has to be briefed by some junior.
Junior.
In the proceeding sheet, his name along with the junior advocate has to be there.
My lord.
And we are following the practice that only senior's name is there. No briefing counsel, nothing. That practice I have been telling you, that whenever senior counsels are there, instructing counsel name also has to be there along with so and so.
My lord.
That should be there.
Should not have.
Cause list shouldn't be there. Cause list is senior counsel's name.
Country it's like that, including Supreme Court, but here, they insist.
There should be some kind of practice you have to develop.
We have no brief, but
You don't have hold a brief. Senior counsel don't have hold a brief.
My lord.
Wherever whoever briefs, they come and argue and go. So therefore, they are not.
The client will write letter to the client also.
That practice should be there. The bar should do that. Senior bar should
Miller.
be yes.
Wait.
Yes. Your name will be there. Okay.
I will serve.
Yes.
item 50,
May I have the regulars? It is a matrimonial dispute, my lord. Due to cold fever, my voice is like that.
It's all right.
It is a matrimonial dispute.
I'll issue notice matrimonial dispute.
I is there, my lord. For it is the allegation, sir.
Who are you?
I am for the mother-in-law.
What is happening in the marriage front?
The marriage has been held in the held.
No. They still there.
They are simply lighting an affair. The additional demand of a dowry. Both the both the husband and the wife are an employee of the software engineers. Soon after the marriage, after 10 days, they are went to their service place, my lord. And thereafter, there is certain disturbances between them. Because of that, the wife lodged a criminal case against the local judge.
Okay, I'll issue notice and I'll send it to mediation. Work it out. Yes, I'll say the proceeding, I'll send it to
That is the only request.
matrimonial.
Yes.
Petitioners are accused in a fire number 4. Since this is a matrimonial dispute, there will be a scope of settlement out of court settlement. Hence, the parties are delegated to the High Court Mediation Center. The coordinator will directly date and intimate at the same time. The parties are at liberty. If I will say that the parties are at liberty to appear through video conferencing also. Parties are at liberty to appear before the mediation center through video conferencing mode as well. As we need to notice so further. The proceeding before so and so is still the mediation process. Awaiting mediation report, please do it. Yes.
16.
Lordship will kindly take it up next week, any day, along with CRLMC 2699 of 2000.
What is this case?
Lordship case and counter case. Matter has been compromised between the parties.
Other case is there?
Yes.
Okay. At least the matter along with
2699.
When that matter is listed?
2699. 2699, I don't have any knowledge because I was not the
Let's check it out. Whenever it is listed, list along with it. Okay.
By
It has
24.
not been listed since long, but I queried the matter.
If it is not listed, give a date.
Yes.
Yes.
2699 of 2023.
22.
20.
Yes.
17.
In this, it is not heard. Therefore, passing of the proceeding pending before the previously the matter was settled between the parties. The husband was filed for 82, and I have under the same in the annexure file. The Lordship grounds about the case number 38.
Yes. Who are you? Husband.
I am a father-in-law.
Father-in-law, mother-in-law, 70. And who is 3? Petitioner number 3?
Father-in-law.
Huh?
First one, petitioner 1, the elder father-in-law, who was the father-in-law.
All of them are at 70s, 80s and all.
Husband have previously filed the.
Okay, I'll issue note. I'll send to mediation.
No, madam.
Actually, marriage has been dissolved. The judgment is filed.
Marriage is dissolved, huh?
Yes.
Okay. Issue notice to opposite party number.
Glance of the case number 38.
It's all right. I'm doing opposite party number 2. So and so which one the state. And
And the party appear before the dishonorable
all right. One
council. They have categorically mentioned. Therefore, it is relevant to appear before the court.
but I have to, without issuing notice, I can't do it. I'll give a short date. I will issue notice, stay the proceeding. While proceeding, you stay, and at least take after 2 weeks. File the process, and once we'll try. If she doesn't come, then I.
Proceeding against the husband are already passed.
I understand it. 1 week I am giving. You try file the process. I am staying the proceeding for these people, and after 1 week I'll quash it because the process has to be followed.
Yes.
Without notice, I can't do it.
Yes.
After 1 week, at least after 1 week. File the requisites immediately.
In course of
Yes.
Item 18.
Lordship, please just minutes. Look, these are 138 NI Act cases, initiated by various complaint cases, In fact, there are 4 complaint cases, There are 4 sub-items.
Who are you? You are the accused.
I'm the accused, But now what had happened was there was a purchase order against which supply was to be made by the complainant of galvanized steel structures for my power plant construction and commissioning methods. There was delay, admittedly. In the email, therefore, correspondences are to that effect, pursuant to which an MOU was executed between the parties. And that is an admitted fact because the complaint case states that. And if your Lordship sees that MOU at page 42,
42.
42,
Yes.
post-dated checks at 43, your lordships will find those post-dated checks. Your lordship has it, minutes.
Yes.
Page 43. There were 5 post-dated checks, PDCs,
yes.
which were issued.
Checks were mentioned, yes.
Thereafter, your lordship takes page 42.
1, 2, 3, 4, 5,
5.
6, 7, yes. 5.
If your lordship takes page 42 for a moment
42, yes.
and
Yes.
sees point number 2,
Yes.
the discharge of PDC will be strictly on the confirmation by NCOR Power Trans, which is this petitioner, my lords, at the due date.
So show me your reply to the statutory notice.
Look, there's no reply to the statutory notice.
Why have you not filed?
That has not
That
been-
should be the first point you should have taken in your reply.
Lordship, that reply is.
You have not filed or you have really not given?
They have not replied, in fact.
Then
There's no response to those.
Then you have to discharge that presumption.
Look, this is an admitted fact.
That's right, admitted fact, but unless you reply under 138 statutory notice, then rightly summons are issued. Now at this stage, you have to go and discharge that. Why don't you settle?
Reverse presumption. Lordship, if your lordship.
You know now the problem with you.
Lordship, I understand that.
That's the
That is
problem.
the.
And why don't you settle? What is the amount? Total amount?
It is 30 lakhs, my lords. Here, and there are.
You deposit 20%, I will issue notice.
20%, my lords, that application is pending before the trial court.
Yes, it's all right. You deposit here. Deposit in the trial court.
That
Then
my lord-
let it be 10%. You deposit 10%. I'll issue notice only to explore the possibility of a settlement, not beyond that. Otherwise, you don't have a case.
But if your
Think
lordship also sees that MOU, there's a.
MOU is all right. That has to be established in the trial only because in the past statutory notice you have not replied.
This MOU has been relied upon by the complaint.
But it has-
in fact state about this MOU.
Where does it in the complaint it says about MOU?
Yes, if your lordship takes page 20, para 7. After breaches, the complainant and accused persons have entered into a minutes of meeting dated 13/10/23, and it was decided and agreed that complainant shall supply the balance materials, and accused persons have agreed to issue 5 checks against the material. It is pertinent.
Then it's very important. It is pertinent to mention here that the complainant has adhered to its part of the obligation and supplied the material as agreed by MOU also. And it is also pertinent to mention that the accused company have also used the material supplied by the complainant as per agreed MOU also, and this also.
Material. My lord, now.
And these are the disputed question of fact to be.
My lord, the trigger event for the checks to be presented was joint verification. That the MOU states that on reaching of the materials at the site,
All these
joint
are
verification has to be
disputed facts,
conducted.
sir. These are all disputed facts. Because if you would have replied to the statutory notice, I can understand that this is the fact. Now I can't inquire about it because I have to go by whatever the complaint says. Because there is nothing before me. If in your reply, if you would have said that fact could have been taken into consideration. That's the difficulty.
That I understand.
What to do?
10% was, as your lordship says, posing deposit. Notice be issued, my lord, we'll explore.
I'll simply issue notice. I will not say anything. Simply issue notice because if I'll say 10%, he has moved our application there in trial court.
Fairly that.
And I'm prejudging that.
Not
I'm prejudging that. The trial court may say for 20%. Because 20% is the requirement.
Is the
If
requirement.
you deposit 20%, I can understand. Why should I prejudge that? I will not prejudge. I will not say also. I'll simply issue notice. Let us see what happens. I'll simply issue notice. Yes, I'm not expressing anything. Yes. Simply. He says that marriage gift.
Yes.
Issue notice and liberty is granted to the petitioner to move application before trial court for adjournment owing to the fact that the matter is sub judice. This much only I can. I understand. Yes. Next.
19.
Yes,
My plea, my lordship. The petitioner have challenged the order dated 24/10/2024
Yes.
passed by the London Court below, your lordship. While the application under section 143A was allowed. What is the case is that, my lord, the petitioner having a piece of land.
What is the check amount, sir?
My lord,
Check amount?
check amount 6 lakh, my lord. The petitioner having a piece of land, my lord, want to solve the in favor of the OP number 2, complaint before the London Court below. There was the agreement, and the consideration amount was fixed to 24 lakhs 50,000. Out of 24 lakhs 50,000, the complaint have paid only 4 lakhs to the petitioner, and it is agreed that the land will be restored in favor of the complaint within 1.5 months. And in the meantime, 4 months has already been elapsed. The complainant did not take any step to restore the land in his favor, for which they have forcefully taken away a check and presented the
So
same
these
check.
things are disputed facts. So how?
My lord. And in the meantime, the complainant himself examined
Where
the
is the
PW1
impugn order?
before the
Where is
court.
the impugn order? Show me. Impugn order.
Page 20, annexure 4, your lordship.
20%.
My lord.
11 page is also 22.
Hmm.
And at this juncture, this court deems it proper to order that the accused is paying 15% check amount.
15%. I generally pass 10%. I can make it 10%. That's all.
My
The
lord,
standard order I pass.
we are ready and willing to pay. I have received only 4 lakhs, your lordship. At any point of time, if your lordship directed, I paid 4 lakhs. I have received 4 lakhs. That's what the agreement, my lord. Agreement I have annexed before your lordship. The agreement dated.
You deposit 4 lakhs. I send it to mediation.
Yes, my your lordship.
You deposit 4 lakhs. I'll send it to mediation. And
Yes.
he says that 4 lakhs I had taken. Let us counsel for the petition by taking me to the documents placed before this court submits that in fact the legally recoverable debt is not more than 4 lakhs. Not more than 4 lakhs. He is ready and willing to settle the dispute. Settle the dispute. তার উপরে লিখতে হবে petitioner is challenging the order dated 24/10/2024 passed by SDGM Denkanat in ICC number 151 of 2022, whereby while allowing the application under section 143 A capital A of NI Act, directed the petitioner to deposit 15% of the check amount. 15% of the check amount. He is agreed by the issue notice to opposite party number so and so subject to the petitioner depositing 4 lakhs. For this court, this court shall be indicated in interest bearing account. The parties are relegated to mediation center, awaiting mediation.
No, I age there. I age there.
I stay.
Always.
The 4 lakhs you deposit, I'm sending it to mediation center.
Yes, hello.
Compromise and give it, and
Yes, hello.
I still report. Okay.
Item 20.
May I please also, virtual mode.
Yes.
The vehicle of the petitioner has been involved in a vehicular accident for the offense 279304A of Indian Penal Code. Thereafter, the petitioner filed an application for release of the vehicle. It is allowed. Because I am traveling. Page internal page 15. Glance. Internal page 15. The vehicle is allowed. This is a bolero vehicle. It is in 2020. Vehicle is allowed subject to condition that lordship. There are imposed 7 conditions, out of which the condition number 1 regarding 25 lakhs of property security lordship. That is to has to me lordship. And now in the meanwhile, the claimant lordship filing the claim case, they have been settled the amount and taken away rupees 5 lakhs lordship. So I press simply so far the condition of 25 lakh that may can be expunged so far other party the vehicle cost at present not short.
No, what is the value of the vehicle?
Bolero आएगा this 2020 Bolero. It may be a
ସେ ଏକ୍ସପାୟାର କରିଗଲା ତେଣୁ ସେ 25 ଲାଖ ପ୍ରପର୍ଟି ସିକ୍ୟୁରିଟି କହିଛନ୍ତି କଣ୍ଡିସନ ନମ୍ବର 1 ଟା ଏଟା ଅର୍ଡର ଟା ହଉଛି 28/9/2020
I know that now.
ଆଉ ସେ MSC ଫାଇଲ MSC ରେ 5 ଲାଖ ସେଟଲମେଣ୍ଟ ହେଲେ ଲୋକ ଅଦାଲତରେ ସେଟଲମେଣ୍ଟ ହେଇକି ଚେକ୍ ବି ଡିପୋଜିଟ୍ ହେଇଛି ଲୋକ ପାଇ ଯାଇଛି ବୋଲି ଯାହା ଇମ୍ପୁନ୍ ଅର୍ଡର ଏ ଯୋଉ ଅର୍ଡର ଟା ଅଛି ଲୋକ ଅଦାଲତରେ ରିସିଭ୍ କରିଛି
I'll issue notice.
ନୋଟିସ୍ ଆଗରେ ଜଣା ପଡିଛି
Issue notice, na? नहीं, लोग को
ये lordship no more required lordship.
Page 18
It is the party lordship.
1 minute, sir, 1 minute. Let us understand.
Handed over to the law and counsel by the respondents, claimants.
But see, claimants, the
Claim has been settled, your lordship. There is no dispute at all. Claim has been settled, your lordship. Only I, my respective submission so far the condition report 25 lakhs furnishing of proposal that may kind be about, your lordship. Claim amount has already been received. There is no dispute at all. This is the judgment of our own High Court, your lordship.
what amount of 16 lakhs will get interest of 6%? No? And what is the stage of the trial? What is the stage of the trial?
Trial of the case, your lordship, has not been begun yet, your lordship. Trial, your lordship, a glance. The accused of the case so far, the driver is the concern. He will face the trial, your lordship. I am the owner of the vehicle, your lordship. I am humbly requesting so far the release of the vehicle, the 25 lakh proposed record may can be expunged, your lordship, because in the meanwhile everything
What do you say? I'll make it 5 lakh.
Property security.
5 lakhs settle the bond. And indemnity bond and all are there.
All others, your lordship, are ready to comply so far the 25 lakh property that is harsh to me, lordship.
Condition number 1, that is I, that is he shall furnish a property security of 25 lakhs for release of Mahindra Bolero vehicle. Entangled is the what is the FIR? Entangled in FIR number?
Bodmal case number 76, dated 13/19. Under section
Bodmal
279,
case number 76 of 2019 for alleged commission of offence under section 279 304 capital A IPC. The petitioner is the owner of the vehicle, and you are not the accused, huh? He is not accused. Yes. He is not accused, Mr. Janaya. Are you an accused there? No.
I have no instruction, lordship, I can say. I have no instruction.
Are you the accused in that case, or who is the driver is the only
Lordship,
accused?
I have no instruction. Yeah, lordship, I have no instruction, lordship.
That's the minimum thing you are supposed to ask your client.
Lordship, VNP, lordship, I am an accused.
No, even if I am asking you, answer it. You should know whether you are accused or you are not. Somebody else is accused.
The judgment of the trial court do not say so regarding whether I am the accused or not, your lordship.
it has been filed against Nikkedeswara Netki, alias Nikki, understand the lordship, the input order and page 3, your lordship, running page 13, paragraph 5, your lordship.
The charge sheet is submitted against Nikhil.
Don't read here and there. Answer the question,
Yes.
whether he was an accused or not.
No, Your Lordship.
I am searching it.
Yes, Your Lordship.
Let me search it.
Yes, sir.
These are the small things you should be ready at least.
But right.
Answer immediately.
Yes, Your Lordship. There is no present.
And for that, I am wasting time. You must know whether he is accused or not. Simply issue notice. Simply I am issuing notice only. Unless I know whether he is accused or not, what can I do?
Lordship only, your Lordship, a glance on
Next
state is the
item.
party Lordship.
Next
Here the
item.
state is party Lordship. State is only obtained instance. Notice is no more.
I have
required.
issued notice only. Otherwise I would have allowed it now.
No,
At
good,
least
your
you should
Lordship.
tell me whether you are accused or not.
No, a Lordship made ke pass over, Lordship, so that
Pass
Only
over
one
today
pass
may
over.
not be possible, sir, because 2 o'clock I have a different bench.
one pass over at least, Lordship, at least
Okay,
one
pass-
pass over,
pass.
I will obtain instruction.
Possible.
Only one pass over.
Pass over. I would have allowed it. Unnecessary. Yes.
Lordship,
Yes.
Lordships, here, FIRs were lodged against the company management, my lords. If your Lordships recollect, there was another case wherein your Lordships was pleased to quash the FIR with respect to the chief financial officers who was arraigned in a criminal case with the allegation that there was a fire accident at the blast furnace of a factory in Bhadrak, my lords. Well, I'm the senior-
You are the occupier.
No, I'm not the occupier, my lords. Now these petitioners before your Lordships are head of finance, the marketing officer, and the security officer.
No. Anil Kumar Dindawani.
He was the head of finance, my lords.
Yes.
If your Lordship takes
I might have quashed that 92 proceeding. Factories Act.
no, your Lordships, there was no proceeding under the Factories Act. your
Then
Lordships.
what I have quashed?
Now, if your Lordship takes page 155,
155. 155. Okay. Yes.
here, my lords, there, my lords, the petitioner was the chief finance officer.
Oh, then the state has considered.
Yes,
his
yes.
case. Yes.
With a report.
Yes.
There was also a report
State
before
has
your Lordships of the
considered that
deputy
he has no role to play.
factory inspector.
Yes.
My lords. My lords, that
You can't seek parity with him.
no, my lords, that instruction be taken, my lords, because the investigation is continuing, and I stand in more or less the similar footing, my lord.
Who are you?
Well, here I am the head of finance, is working under the CFO.
How many accused are there in this case?
Lords, if your Lordship takes the FIR,
8 Your Lordship. August.
See what had happened in this case.
That Your Lordship, 155, another 2 accused, Your Lordship.
Some accident has taken place.
Yes.
And the account officer was entangled in this case. He has nothing to do with this. So
marketing,
therefore, I issued notice to the state. State considered that he has no case.
Yes.
On that basis, I have quashed it.
In that.
And he says that he is also similarly situated like the other.
That particular side of instruction.
And simply issue notice.
Because the presentation is similar with the.
Okay.
instructions.
And learned counsel Mr. Das, learned counsel for the petitioner, has drawn my attention to the order of this court passed in CRLMC 451 of 2023 dated 4/9/2024 and submits that case of the present petitioner is squarely covered by the said order. Issue notice to the state council date. Mr. Mohanty accept notice and seeks 1 week time to get instruction in that regard. Please the matter. Yes. After 1 week.
Pardon me, the honor is not the accused, Your Lordship.
Wait, not like this. Yes.
22.
Oh,
My only problem is this. The matter is posted there.
what are you challenging here, by the way?
I have challenged Millards.
I'm not hearing it. Huh? I'm not touching it.
I have challenged the order of cognizance and issuance of protest in a protest petition.
Okay.
Saying that no case is made out there. on that.
But
My-
now SLP is dismissed.
It has been dismissed, I agree. But the point which I am raising here, That was never raised nor considered.
You have a right.
And you can also file answer bill. There I have appeal.
That also, my lords, has not been listed so far, though it was posted specifically.
When do you want? I'll just put it there.
Lords, as soon as possible, because the matter is posted to today for my appearance. Now, in view of the fact that your lordship will not hear, I'll have to take an adjournment. So if your lordship directs that it may be placed before the acting chief justice for listing as soon as possible.
Party subject to subject to the approval of the honorable acting chief justice. List the matter. You tell the DR to list it next week, Monday, Tuesday. You tell this one.
I'll make only a small prayer.
Yes.
This order of your lordship, can it be uploaded? So
Today
that-
only.
Yes, so that I can show it.
Yes. Yes, sir.
Short point for consideration here, my lord, is, my lord, may take the synopsis, my lord.
Synopsis.
A.
Okay. Yes.
My learned senior is there with me.
Both my learned senior is there. Both of us were appearing to the same.
Same. Okay.
My lord, the FIR, my lord, A,
Then there can't be a short point then.
no, very short.
Shortest possible.
Very, because, my lord.
You people have might have made it shorter, but not.
No.
Yes. Yes.
Paragraph A, page A, my lord, may kindly see.
Yes, I'm there.
The FIR pertains to an alleged corrupt practices involving officers of the region roof and certain third parties. However, Ideal has not been named in the FIR. My lord, I am a company. My lord, a company registered under the Companies Act. I am not in the array of accused. I have been issued a summon under 94 at page 15, what I impugn. today.
50
15.
15. Okay. Yes.
My lord, as if it's a roving inquiry for the purposes of expanding the scope of bridge and roof, my lord. I have no connection. This company has no connection whatsoever with the bridge and roof. Nor am I a contractor with them, nor have I ever tendered in their tenders. I have been issued a notice, my lord, may kindly read, and for the purposes of making available documents which are privy to me. And therefore, an infraction clearly, my lord, of Article 20, subclause 3, as well as 19(1)(g).
No, it is only summon.
Yes, my lord. Why should I appear, my lord, when I am not in the array of parties, nor am I, nor my lord, may
And
kindly
it is
read this
not.
section.
It is not even issued to the managing director. Any authorized person can go and give the document.
No. Documents that they have wanted have already been given earlier. My lord, what is happening today? I am now called upon 7 or 8 times to the CBI for the purpose of making available material.
IM means who?
Madam, the company. The company, my lord,
company means the promoter or director. Nobody knows. It is only the authorized person.
Yes, authorized person.
Send a peon also with all document and send it.
No,
If it
my
has
lord,
come-
why should I send, my lord, is the point at issue. My lord, may kindly see, take 94, my lord.
Can I just?
Yes.
90.
For a minute, before your lordship goes to that 91, corresponding 94.
Yes.
Kindly see page 20. Just
Page
page 20.
12.
Page 20.
22.
20.
20.
Lordship will kindly flip over to that page.
Yes.
Page 20. But this, here your lordship will get the FIR.
Yes.
Lord, kindly see the FIR. The FIR here is a secure information has been received from group manager so. Lord, the gist of the FIR is a Penta studio in the grid of getting work from bridge and roof. That's the FIR. Penta Studio, Santosh Kumar is the proprietor or managing director. In the grid or in the for the purpose of getting a work from bridge and roof has gratified the officers of bridge and roof. It's a PSC, public sector. That's the allegation. So bridge and roof officers
Santosh Marana Pentasa, and these are the, and one Aditya, one Mahapatra, one say. No, Mahapatra. Devadatta Mahapatra. Of course, Lord, Devadatta Mahapatra is the managing director of this company. This petitioner company, yes. But that should be placed before my last. That is there, yes. So Pentasoft, Regent Group, these are the two allegation is there in the affair. There is no allegation against Devadatta Mahapatra or this Aditya Dev Infra in the affair. Absolutely no allegation.
Anybody has any idea what is the angle of investigation?
Exactly.
And how I access it or not, you access it? Nobody knows what is the angle. They are asking some document, give it.
Lord, I'll just tell you, Lordship, with reference to the law, Lord, I don't mind to give the documents. Lord, majority of the documents you have already given. Lord, I don't mind.
I can understand if you had a given that if the managing director of the company is called, they say that authorized representative to produce this document, XYZ document.
Is already an accused.
Then it's more of a reason that you give the document.
Managing director is already there with you.
So therefore it's more of a reason.
No,
then
arrested, no?
Was arrested.
Managing director.
Then your company has something to do with the offense. Give the documents.
No, before that, just kindly see that 94. Kindly see.
Yes.
Under what circumstances they can give this summon? Kindly similar. Before that, they have to formulate, they have to make out a point against this company with reference to the investigation in the FIR. But what is the FIR investigation? Regent Group and Pentasoft.
And Mahapatra.
Mahapatra is not there.
Not there.
You said Mahapatra, who is managing director, he was out.
I said Mahapatra because I have listed Mahapatra unnecessary.
So the necessary is not the issue to be discussed today. Today is whether any illegality in giving in a notice to you to supply the document.
That's right, but kindly see 94.
And fortunately, there is no name. They don't ask X or Y. They said authorized. Send the document through authorized.
Can this kindly consider section 94? Kindly see
94 of the
this is BNS.
BNS.
What they will say? They will definitely say this. Kindly see section 94.
94.
Yes.
Yes, sir.
Whenever.
1 minute. Yes.
Whenever.
Yes.
Whenever any court.
Hmm?
Whenever any court
or
any officer in charge of a police station considers that the production of any document, kindly see note, production of any document, electronic communication, including communication devices, which is likely to contain digital evidence or other thing is necessary or desirable.
Yes,
for
this
the
is
purpose
important.
of any investigation.
Desirable for the purpose of any investigation.
Any investigation.
Yes.
But any investigation cannot be beyond the scope of the FIR. That's what
I
I'm
don't
trying
know.
to tell you, Lordship. But it can't include anything.
I can't restrict the investigating officer to investigate according to the choice of individual. It is open to the investigating
But
officer.
I'm not calling upon your Lordship. to
Any
restrict.
investigation desirable. It is not even
So
desirable.
they must be subjectively satisfied that this is desirable.
That this provision required to write a reason for calling you documents.
On the face of the allegation in the FIR.
Whose subjective satisfaction?
Yes.
The accused subjective satisfaction.
Satisfaction from
Or the IO.
From the FIR.
No.
Look, investigation has to be on the FIR. It
That's
can't,
right.
that is what Sigdat here says. Kindly see.
I don't see the allegations are such. See, it is a wider allegations. And they are investigating. You tell me, let us put a rest. You tell me the shortcut to this.
Right.
You give the copies. Simple. You send someone and give me the copy. Let them do it. Don't get into technical.
Kindly consider that today, I have in the process what they are doing, what is the kind of harassment I am suffering. Kindly consider this.
When you say I am who?
Company. This company, no, where is
If you are managing director is
no, I am not for the managing director here.
No, that's right. But the company, they have not called for the company. They have asking
the company.
See, let us see the documents.
Kindly see,
What are the documents they are asking?
Kindly see the summon first. Kindly see.
Yes.
Kindly see. How can this type of summon be issued? Kindly see page 14. Kindly see.
Yes, I'm
Omnibus.
Aditya, authorized person, Aditya Dev Infratech. So and so. Then you are asking, not why I was trying to show your lordship that someone is Bridge Group and Pentasol. Not my company, this company of executing any work under the earth, he is required to produce those documents before them. But what they are doing is they are writing letters to my different employers, and now they are hesitating to all
Okay,
work.
let us see the documents. Let us see the documents.
Kindly see.
Details of all the project done by so.
Kindly see.
So, these things are classified information.
But
Why don't you give it?
the details of all the project, kindly consider how vague is it, this. Details of all the projects without.
Whatever you think correct, you give it.
Not that must have a
Certificate
nexus
copy
with the
of
allegation, my lord.
balance sheet. If
Not
they're
that
asking
must have a nexus with the allegation.
certificate copy of ITR. They want to find out something. I don't know what's the consequence.
It must have a nexus with the allegation in the FIR.
Do you have any problem filing all these documents in this court? In this court?
Let me not sigh out from this.
Do you have any problem in filing these documents before this court?
Document I'll file, man. Kindly consider this. How vague is this summon?
Yes.
How vague is this summon? They must specify that the allegation in the FIR has.
No, no.
Good.
That you can't.
So
You can't demand the police to disclose the angle of investigation. Not at all.
Angle of
Not at all. Exactly you are saying that.
No, I'm not saying that. Kindly consider.
No,
Projects happen. Not kindly see.
This is not the law.
Not kindly consider all the projects. This company is since last 20-30 years.
You give whatever
50 years.
they may say.
Those documents
Insufficient.
are with me. And today, what they are doing is, in case of failure, they are approaching for cancellation of mine. That is the problem.
Cancellation?
Bail.
Bail of whom?
Of the managing director of the company.
No,
If
that's-
the company is not failed.
Your managing director is involved. They want to
Sir,
investigate it.
Kindly consider managing director is involved, not involved. That is a different aspect altogether. But he is not before my.
You supply the documents, and whichever document you don't want to supply, give the reasons.
Yes. Lakshmi,
Give the reasons.
clarify that.
I don't want to supply because of this reason.
Yes, Lakshmi, clarify
If you
that.
want to do it, and the consequence will follow.
Yes, Lord.
And they will do.
Let them clarify.
75% of the documents are on the public domain. Are all available in public. There is only an harassment, my lord.
It's
So, see, if there is an,
Well, I'm
those
only-
documents are in public domain.
Yes. Why can't they? Why can't they
the
take?
hunch? You can very well give.
What they do, well, what they do immediately is write to the my employers where I have contracts,
Yes.
where I'm nowhere in nowhere.
Show me any such document.
Yes, my lord.
Show me one.
Yes,
So, I can-
yes.
Show me. They are
Right.
writing to
Yes.
your contractor. people.
Yes, yes.
Lord, those documents I can show you.
Hmm.
Those documents.
Hmm.
Where are those letters? You are saying that they were issuing letters to our employees. Back to those.
Annexure 6. देखिए वो पेज it. 22.
No, to our employer.
To our employer.
They are writing letters, no? Yes.
If that is the case,
We'll file an
that
affidavit.
the investigating officer is transgressing his
Jurisdiction.
domain
Exactly.
by trying to influence your business.
Yes.
Show me that, then I can understand. I can try and do something.
Right, Lord. On Friday, your lordship may take it up. We'll produce.
Try.
Yes, yes.
See, if
Right, Lord.
that is none of his
Lordship-
business. It's none of his business. He can investigate, but he can't tell
No,
you.
but don't
He can't write letters to your clientele.
Yes. My lord,
Show me
but
that.
we
Show me that.
no, my lord, we
Then I
cannot-
can understand that.
we probably cannot say that, my lord. We'll file an affidavit that letters have been issued.
Giving specific detail that
Yes.
investigating officer
Yes.
is writing to our clients.
Yes.
Don't do business with this man or that man, whatever. Whatever.
Don't do.
Please,
Then-
Don't do, my lord.
don't say like query.
They'll not write.
ठीक कर देला माने काम सर.
আমার তো সবু মানে
What then you are making allegation against that? You tell me what are the allegations?
Sir, that's why I'm saying, Lord, our employer, suppose 5 years back we have executed a project, or even 2 years back where some project is ongoing.
give
Our
us
payments
details.
are due. Today, what they are doing is, since this company is someone, they are writing to my employer and they are blocking our payment.
So show me that letters.
I'll show that. I'll show that.
To bring that
I'll
on
show that.
record.
I'll show that.
Then I'll see. But in so far as these,
Those are there. Lord, I'll show you.
but in so far as the summon part is concerned,
My lord,
whatever the document they are demanding, Can you shy away from filing those documents which
No,
are
no.
in public domain before this court?
My lord, I'm only
They
saying.
have already given it.
You file it now.
Most of the documents you have already
You
given.
file all these documents.
We
Right.
have filed, under Annexure 6 series, we have filed those documents.
All the documents you file.
Majority of the documents will.
Not majority, I'm talking about all. documents.
All, my lord, I may not be having, supposing, my lord, 10
They
years
are
back,
not
15
issuing
years
to us,
back, I
yeah.
may not be
If
having.
you don't have the document, give the
Uh.
reasons why you don't have and file an affidavit.
Yes.
And who is appearing? Yes, Mr. Who is appearing for?
I'm appearing.
And if you
I'm
have all the
appearing on-
documents placed on record, you take it and you investigate.
With your lordship's permission.
Your
You
lordship will
have
take
all-
instructions in the.
See, what instruction? You have called for the document and you said that
Yes, your
let
lordship.
an authorized representative come and give you the document. If the documents
Your
are
lordship.
form part of this record, you take it and do it.
Yes.
Your summon is
Yes, your
satisfied.
lordship.
You got the
Yes, your
document.
lordship. I understand. Yes, your lordship. I'll convey
You
it
got
to
all the
Mr.
documents.
Sarthak Naik. He will convey. Yes, your lordship. I understand your
Did you
lordship.
follow what
If the
Trying to
document.
say?
Yes,
You have
yes, your lordship.
summoned them to produce documents. These documents are produced in this court. Take these document, do whatever
Yes,
you
your
want.
lordship. Yes, your lordship. Purpose is
You
served
file all the
then.
document here. You file all the document, I'll dispose it up.
I will seek your lordship's permission. May.
Yes, yes, Mr. My learned friend, please.
If I may kindly submit minutes for just to, well, just.
Yes, yes,
1.5
yes, yes.
That's what it is, plus the case is that Bridge and Roof, a PSU, their group general manager is indulging in corrupt practices. For that purpose, that is the FIR, that is what is recorded in the arrest memo, that is what is recorded in the observation memo. Observation memo means what transpired during the act of seizing that 10 lakh rupees. Now, everywhere, your lordship, the allegation pertains to Bridge and Roof, group general manager indulging in corrupt activities, that is Chanchal Mukherjee. And he has received money from one Santosh Maharana, who is the director of Penta A Studio Private Limited, for getting some work in Vizag. Now, Millets, what happens? Where do I step into the picture? Their case is that the prosecution's narrative is that 10 lakh rupees that Santosh Maharana gave to Chanchal Mukherjee gave to my managing director in Bhubaneswar. Therefore, the company, Aditya Dev, the petitioner company comes into the picture. Now, Millets, here it is a case of PC Act, which relates to a particular public servant.
The money trail, they found the money trail with your managing director.
Public servant and a concerned department. Here it is Bridge and Roof, which is a PSU, not even a department. It's a PSU, Millets. It's a central government PSU. Central government PSU, Bridge and Roof and its group general manager is being investigated. There, Millets, they're writing letters to me to provide documents relating to SCST department, SSCPD department of the state government, which Millets, and in a case where Aditya Dev, this petitioner company has never worked ever with Bridge and Roof.
You simply say, I have not worked.
That we have already said.
Where have you said?
Yes, it is there.
In this, that's what I'm saying. Listen to me. Let us sort it out. In the summon, there are about 6 documents demanded.
Yes.
Okay. And you place whatever document you have in your possession before this court, and
Yes.
I'll dispose it up.
Yes.
As simple as that.
Yes. We'll do that.
As simple as that. And the document which are not in your possession, simply say that I don't have a possession.
That puts an end to the problem.
That at the end of the, because they are not asking for any interrogation or anything. They say that to send someone, give the document. Whatever document you have, you place it before this court. I'll dispose it up.
Only aspect, Millets, is what it is an endeavor to extrapolate the ambit of the investigation to anything that lies under the sun. Now, let's hear. You are investigating.
I don't know, and I can't restrict the investigation.
I bow down to that. But Millets, there has to be some causal connection. There is no possible.
Can the court while exercising 482 will start investigating a separate investigation and I'll see the links? I can't do that.
What I will respectfully say, as your lordship has rightly.
That is the best way. You submit the document. If you don't have a document, you say that this document, file an affidavit.
And he will not.
File these documents. Say that these documents are not in our possession, or for XYZ reason I don't want to give,
Filing an affidavit.
and I'll send it.
And my lord, another aspect, another important aspect is, my lord, these letters being written to people where this company is no way concerned.
Those things also place
Yes.
on record.
Yes.
Those things I'll dispose it up on that
Yes.
basis.
Friday, Millets.
Friday, my lord.
Great.
Monday,
Your Lordship,
Monday.
may I pray one
Yes.
week's time, Your Lordship? We will also seek instructions in the matter till that time, Your Lordship. May I pray 1 week's time, Your Lordship?
They will.
May I plead
No,
that
no,
the
I'll
matter be
dispose it up. You need some document, I am procuring document for you.
If they take more time than interim.
I am procuring document for you. 1 minute. Yes, next.
We have a problem about,
Just keeping it.
Monday? Monday. File an exhaustive document, affidavit, and along with all.
in the
possible
meantime, let them.
Whatever you have.
In the meantime, let them not force me to, go to them all the time.
Monday, by Monday, they are asking 1 week time.
Okay, in view of that.
See, 17th,
My lord, just instruct them that let them
no,
not.
17th December, the summon was issued.
Yes.
You have not gone. Today we are in January.
We have gone. That is what is annexed.
It's all right. File, I'll dispose it up. File it on Monday.
Plus, what they are doing, they're issuing notices even for compliance on Saturdays and.
You
Sundays.
mention it if it's notice is issued. Mention before.
Yes. It is there, today also.
Today also 7 of them have come.
Don't go.
Today issuing notice.
Don't go. You know how to avoid.
Plus, we write. I'll show you Lordship the letters. I'll show your Lordships. I write to them that I have approached your Lordship.
Hey, everybody knows that CBI when investigate, they hype at the investigation stage. And the end of the day, everybody take it.
Everybody?
And a typical police officer investigate and conviction is 100%. They know how to do it.
Exactly.
And the CBI and all, they hype at the time of investigation, as if something big has happened. And when it's put to trial, everybody is acquitted.
Best example is 2G, my lord.
Everybody is acquitted. They play to the gallery.
Absolutely.
At the time of
And,
investigation.
I mean, sheer harassment, my lord. They come, then they tell me that you give evidence against myself. Contrary to fundamentals of law. That's the problem, my lord.
Okay.
Write to them that I am before your Lordships in CRLMC number such and such. Kindly give us time so that we can.
And you choose now whether you want a dismissal today or Monday you want.
No, that's not. That's all I was saying. That's it. Maybe some.
Monday do, I'll dispose it.
Very good. I'm so grateful. 24th.
Do it, eh? Perfect. Yes. Yes, sir.
My discharge application has been rejected under Annexure 5.
Annexure 5.
Page 95. There was a soft point involved in this case. That on the basis of schedule offense, now ED registered ECIR and investigate the case. Now schedule offense investigation is on, it has not been completed. But during pendency of the investigation of schedule offenses, now ED tried to complete the trial. Well, according to me, it is not permissible in the eyes of law. ED should have waited till completion of investigation. Thereafter,
No, what you have moved an application under 227 which is rejected.
Yes. Only on this ground, because since my schedule offenses investigation is going on, don't proceed with the trial. Why am I not making such submission? For example, I will not be charge sheeted. If the accused will not be charge sheeted in the schedule offense, can the proceeding under the ED?
Where is the legal bar you show me?
Where
is the legal bar?
Your Lordship kindly see there is a.
Logically, you may be correct.
No, not
logic.
logical.
Is not always.
If a Lordship will find from the 4-5 judgment, that Madanlal Chaudhary case.
Show me.
Page.
Show me that.
Para 104.
Show me that TMLA case should not proceed before.
What is the language?
Schedule offense. Where is the legal bar?
I'm giving.
Logically, you may be correct.
Yes, 4 to 5 judgment, not the one. Where the Supreme Court has
show me
considered that that has been reported in 2023, volume 12, page
give me
1.
That
library.
Shall I put it
400 or 500
Shall I put it
pages.
next week? Get the judgment, otherwise you don't have it.
Yes, I'll
If you can
supply.
satisfy on judgment, then
Yes,
I can.
not the one
Legal
judgment.
bar.
Not one judgment, but there are 5 judgments in this light. But unless charge in a civil offense, charge sheet is submitted, or prima facie evidence is come out, you don't proceed with the PML.
Show me that exactly.
Yes, that my lord, I will show that.
Exactly that point you show.
Yes, yes.
And where have you taken
That I
that
am,
point?
my lord.
Why?
Entire
Then,
case. That is my entire case.
Then how can you ask for a discharge?
What?
You can ask for, how can you ask for a discharge?
Because, my lord, why I have prayed
You
for
can very
discharge?
well move.
Why I have-
Please stay.
But why I have prayed for discharge, my lord, kindly bear with me. On the basis of, my lord, property belongs to my father and my married daughter. My lord,
That is again on merit.
no, married daughter as well as father. Property of my father.
On merit. On merit you want.
Yes, yes, yes.
Are you concentrating your case on merit or concentrating
No,
your
my
case
lord,
on the
merit
first
as
one?
well as, my lord, merit as well as, my lord, technical point. But here, my lord, only this is the point, my lord, 2 points. But that judgment, my lord, 2 judgments of this court, I think, my lord, Vijay Madanal Chaudhary, page, my lord, 2023, volume 12, basis page 1, specifically para 109. My lord, kindly
Yes.
noted it. 2023, volume 12, SCC, page 1,
Yes.
para 109. Well, answer is that.
Yes. Get the. Yes. Do you want to say anything?
Your lordship knows, once FIR is registered, ED gets power to investigate and proceed. What my friend is saying, it's not correct. Unless the charge sheet is filed in schedule offense, ED should not proceed. That is not the law. Law is once FIR is filed.
But both the cases should try together.
That's a different question.
That's
a different question.
that's the position.
It's not always.
Or not always.
That is also not always. Here, my lord, if your lordship looks to that, huge disproportionate asset was recovered, my lord. Your
Because
lordship-
PMLA proceedings are contingent upon the schedule offense.
It is
Contingent upon that.
contingent, but now it is a independent offense also.
It's an independent
It's
offense.
an independent
So
offense.
therefore,
He has to also explain, my lord, from you, what is his source of income money, from where he got those money, what is his source of income? And till I can place, my lord, he was not filing income tax return till 2015-16. Subsequently, in the name of wife, he had filed some returns. Thereafter, also huge disproportionate assets were found. So he is to also satisfy from where he got those money, my lord.
that is on merit again.
Yes, my lord.
On merit. Okay, I'll put it next week, sir. Mr. Pradhan,
My lord,
I'll put it next week.
what my plans, my lord.
Either I'll put it next week or you have to give me your mobile.
No.
Either.
That, my lord,
That
answer.
will be costly.
That I am searching the answer. What my friend make a
So let us do it in next week. Now you got what is his point?
No,
And meet that out.
but unless my lord, the charge sheet is submitted in my lord, schedule offense, if the prosecution says no, there is no schedule offense at all, can they proceed?
Then it can be dropped. You
Yes,
move an
that
application and
is
get it
the
dropped.
entire case. That is my case. Investigation is on.
But
on
you
the
can't
basis of my father's property and my
prevent
daughter's
the
property.
PMLA court from framing charges.
My lord,
You can't prevent the PMLA court from framing charges.
but once charge is framed, that means my trial is on.
That's it. If the trial is on, at that time, if they file a closure report, you can move an application and drop it.
By the time closure, my lord, I will be convicted.
How do you know?
Because
How do you know
my
that?
charge sheet has not been submitted since 2010.
Have you challenged that part? You file another petition. There.
That petition,
FIR was registered in 2020.
that petition also I have
FIR was
filed.
registered in 2020. My friend is saying.
Yes, I'm
Charge sheet
thinking.
is since 2010.
All right, 2020.
Okay, next week. Next
But
week.
I had that filed that petition.
Next
That petition also rejected.
Get ready with judgments and all. Okay.
Okay.
Okay, next
But the date has been fixed to tomorrow for framing of charge. You let's say may indicate that file a petition there. Otherwise,
Framing of charge is that-
Friday.
Yes.
Friday you come.
Yes, otherwise my application become infructuous.
Friday you come. You satisfy. Otherwise,
I'll
Number of times he took adjournment before special court for hearing of this application and framing of charge. Now, after rejection of this also, he is seeking time, Lord. Now, earlier also, my Lord, he moved it for this.
18/11/2024 ରେ order ଟା ହେଇଛି.
you should have come with all judgments.
Yes, I 18 ନାଇଁ ମୁଁ ତ କହୁଛି ନା ଜଜମେଣ୍ଟ ମୁଁ ତ
since last
I need to
4
see
to 5
this.
months, you have not allowed the special.
लेखिकी दिल्ली
court to
टिके
get the
नहीं आसा।
charges below.
वो लेखिकी दिल्ली भी गोटे
Friday.
500 page is very difficult on that.
No, you get the relevant part, whichever paragraph you want to rely on. Yes, next.
25.
You have to indicate that make an application there, otherwise you will.
Friday I'm keeping. That's the reason I'm keeping it Friday. Yes.
मतलब
Friday I'm keeping. This Friday.
नहीं सेठी पर charge frame पे अच्छी
Then you should have come with the judgment and all. See the urgency. I can't pass interim order like this.
नहीं interim no मुखाल के लिए adjournment application
You
का
do
देखे
it.
थे
Who stops you? Do it.
मतलब क्या charge frame का
And you have been managing it. You can manage it one day.
नहीं अगर
You will manage it. I know.
नहीं ही पे उनको अगर last order टा देखो ना मुझे सही पे करो otherwise मुझे अगर last order से जिस वक्त कर दे
Sir, you should have come with full preparation. You can't come with judgment in your mobile and argue the matter. You should be ready. I'll pass it over. I satisfy me.
मतलब मुझे मौके दो
Satisfy me. It can't be like that. You file a petition, you come without preparation and ask for a stay. That can't be. At least you should satisfy me that yes, you have a case, then I definitely I'll say. Complete say. If I'm satisfied. If this point clicks, show me that paragraph. If that is there, I'll say it straight away.
all right
Show me that paragraph. I'm just passing it over.
Okay.
Get it? Yes.
25.
May, as you can see, page 10, NBW was issued 21/2015, my lord. Date of bail order 21/9/2013, my lord. Page 9.
15. Now you are coming.
NBW 15, first time, my lord.
Give 2000.
Date of 21/9/2013, my lord. Page 9.
15, the NBW was issued.
Yes.
Today, 10 years only. Only 10 years. 2000. 2000. If you say I'll increase. Yes. 2000 and appear before the court on 25th of February. Yes.
Rani page 30 or shit. NBW is it 49/2022.
22. Okay.
Rani page 30 and a bail order. Rani page 29.
500.
24/5/2012.
500 each.
Of that.
27
each.
27 NBW was issued on 9/10/2023, lordships. He was on earlier on bail, my lord, under Annex 2, my lord.
Okay, 500. Yeah.
Great.
28.
May I please, my lord. It's a Belgium matter. Petitioner released on bail 10th November 2010 and NBW issued on the date 20th September 2018.
20.
Or 18.
18. 1000. Yes.
29.
7/1/2025. 7.
Local bar. Yes. Yes.
It was NBW dated 7/1/2025 and he was on bail matter 27/6/2020.
500.
30.
May I please, my lord? NBW issued on 29/6/2023, my lord. As on bail 22, my lord.
20?
No, petitioners are released on bail on 26/10/2022. No, NBW issue against 29/6/2023, my lord.
Okay. 500 each.
Okay.
31.
31, my lord. I have filed a miscase for dispensing with the filing of certificate copy. NBW was issued on 23/10/24. He was granted bail on 20th April 2024.
500.
And I will pardon. I read certificate copy dispensed.
Dispense with that one.
Problems. But I may pardon. Another prayer, my lord. Item 13, vigilance matter. My lord, copy टा दे है जी DCRLM से copy अच्छी. I got दे जी.
Which item?
Item 13 टा pass over है जी. 13.
One
page जोड़े copy दे. यार नहीं है वो copy
Give a
दे.
copy, list it after 1 week after.
1 week after.
1 week, yes. 25 for link.
21 की 22 कर दे.
22 please for 22. Yes, next. 31.
31.
31 टा कर दे.
32.
Page 8. But NBW issued on 0.69/2022.
Your Lordship, space 7 on 5/12/2018, he was on bail.
7.
Item 33, that's order of NDW was issued on 10/10/2017. The petitioner is on bail on 27/5/2016.
NBW?
Order of NDW is
17.
10/10/2017.
2000. Yes.
34.
Yes, sir.
This review petition has been filed to review the judgment passed by this honorable court in second appeal number 115/2001, ordered by judgment dated 29 of February 2024.
Yes.
But the moot question is the plaintiffs, who are the petitioners before your lordships, they are the petitioners. They filed a suit for partition of the ancestral property which stood recorded in the name of their grandfather. The suit was dismissed by the learned trial court, holding that during the lifetime of the father, the plaintiffs cannot maintain the suit, interpreting Section 8 of the Hindu Succession Act. Against that, an appeal was filed before the appellate court. The learned appellate court, relying on the judgment of the Vinita Sharma and Rakesh Sharma, which has been decided in 2022, held that the daughters have become co-personers and they have an interest in the property and they can maintain a suit for partition. Against that, the defendants, in fact, the purchasers, they have come because plaintiff's father.
Lease pendency purchaser or readily purchaser?
No, the plaintiffs are the daughters of defendant number 2, who, being influenced by defendant 6 and 7, got the sale deeds executed. Therefore, this partition suit was filed. The learned appellate court decreed the plaintiff's suit, holding that yes, they have every right to file a suit for partition, and the share also with allotment share also indicated.
Yes, yes.
Against that judgment, my lord, the
Defendant.
they came before this honorable court. But unfortunately, when the matter was called for hearing, the plaintiffs were, the learned counsel appearing for the plaintiff was not there. And by a misstatement made by the defendants saying that the Charu, the recorded tenant, he expired in 99. The honorable court held that in view of the law decided earlier, that is 2016 Supreme Court, Uttam Singh and Sovak, when the father was alive, the plaintiffs cannot maintain this suit.
But that part is the erroneous.
Yes, and against that, my lord.
Show me that part.
And against that, my lord, we have moved to the honorable Supreme Court, and we have pointed out that, and the honorable Supreme Court directed that all right, you file a review application before the honorable court and given liberty.
Okay. Okay, issue notice to opposite party number. Written notice. Pursuant to that Supreme Court order, you have filed this.
Yes, my lord, I have filed.
Leave is granted to you.
Page 41, I filed.
35.
May I please? Here, my last.
Yeah, the other liberties also you have.
My lord.
I was wondering whether that liberty,
That liberty also has been given.
Because after that judgment, if you don't take liberty, you can't challenge after the
that liberty has also.
That liberty is also there. Yes. Yeah.
Item 35.
May I please? Last time you also wants to see the Ravi Prakash judgment, my lord. And here, my lord.
Paragraph number 4.
Yes.
How many cases?
Well, there are 3 cases in the
8 cases.
Yes.
In the sub item, I am appearing, my lord.
Well, 3 petitioners in 1 PS case.
Right. You say 8 cases?
No, no.
3 cases.
Three
Yes.
cases, 3 petitions.
Yes.
Yes.
No, 1 case, 1 PS case, 3 petitioners, my lord.
Recovery?
Recovery 154 kg, 900 grams of ganja. And so far my client is concerned, is a local person having no criminal action, and they are inside custody since 19/5/2023, my lord.
19/5/2023. Yes.
And the last occasion, you also peruse the status report.
In this case, more than 3.5 years. Very good.
Yes,
In
ma'am.
your case,
Only 1 year.
All the petitioners are in judicial custody since 19 May 2023, my lord.
then how many years?
And you also can see
Almost 1 year, 8 months, your lordship.
1 year. In that case, 247 kg.
Yes,
In your
ma'am.
case,
Yes.
154 kg, 900 grams, my lord.
400 gram.
And exclusive position from the petitioners.
All
Because
the-
in one,
all
yes,
the-
my lordship.
The status suppose you also last occasion peruse, my lord, that is flag E. Only one witness has been examined, my lord.
Out of 14.
And he became hostile. He's a
Police
government-
witness.
Police, my lord.
police witness.
My lord.
One of them is got hostile. And what else?
13 witnesses are there.
Huh?
13 witnesses are there,
Huh?
prosecuted, and
Yes.
only one witness has been examined. Last occasion, your lordship was directed for the status report, my lordship. It was in flags.
E.
E, my lordship.
Na? One witness is taken out of 13 charges to be.
Yes.
That is up till 10th January. Further, I am interpreting here with a copy of decision. And he is not supported.
No, my lord. He's the police, my lord. Police constable. He has no support.
And the vehicle that has been, my lordship, was the own that Abhijit Vidya is the owner of that vehicle, my lordship.
Owner of
That vehicle, my lordship.
Abhijit.
Yes.
And what about the other two?
They are the co-accused, my lordship. They are traveling with him.
And who all are the relevant witnesses? In the charge sheet, just see.
Page 10.
Who all are the relevant witnesses? From the
My lordship.
charge sheets.
Yes, my lordship.
Who all are the important witnesses according to you?
Diptimai Dhura, who is the complainant, my lordship. He has also, no one is charged. Only one person is, my lordship, has been given his depositions. And
That he has
other-
not supported their own police.
he is the constable, I think, my lordship.
Constable who accompanied with the IO. He says that I have not seen.
Well, that part I have not.
Complainant is Diptimai. And who else?
My lordship, let the witness maybe.
You have not read it.
Yes, my lordship, I've read it, but I have not seen the deposition copy, my lordship. Now I have received.
You
the
read
deposition.
it and Ravi Prakash also give it. Next week.
Yes.
My lord,
You
my
read it.
submission, your
Yes,
lordship.
yes.
In the month of August 2024, your lordship directed conclude the trial within 4 months. Even after the order of this honorable court. in
Where is
another
that?
co-
Where is that order? Where is that order?
BLPL number 752 of 2024. Another co-accused order, my lord.
Where is that? Show me that order.
That order may be before this honorable court, my lord. Through
No, it's not there. You get that order also. In what he says that in the bail application of co-accused, this court has directed to conclude the trial within 4 months. That is also not complied.
That is
Yes,
not
I
complied, your
will-
They
lordship.
have 3 ground now.
Yes,
They have
ma'am.
3 ground.
Yes, ma'am.
Deal with that.
Yes,
First is time fixed by the court.
yes.
The trial is not concluded. Second, one of the police officer who accompanied with the investigating officer. He has not supported the
right,
case.
yes.
He is an UR officer, not supported the case. Third is 1.5 years. He is, they are already in
In the
custody.
custody, yes.
Ravi Prakash,
Whether
they are
it's a-
relying
yes,
on
my
Ravi
lordship.
Prakash. In Ravi Prakash case, 247 kg recovery, here 154 recovery.
Yes, my lordship. I will.
So if 3 years, 2.5 years or 3 years in Ravi Prakash for 247, here 150, one and a half, satisfied.
Yes, my lordship. I will verify.
So
my
these are the conditions. Okay.
Having no criminal antecedents also, your lordship.
No criminal entity.
Yes, yeah,
Yes.
yes.
These are the material consideration for the bail.
Yes, my lordship.
I think they are entitled.
I will check.
Think over unless
Yes.
you say otherwise.
Yes.
Think.
Grateful, man.
And that's you are in next item. I'll do that. This matter will go.
Over here.
36.
May I please? I may permit to place on behalf of Mr. Mishra. It's a case. Initially, it was a case under section 380, 457. Now, charge sheet has been submitted 457, 380, adding 411. The accused who has been forwarded with 411, he has been granted bail. Madam, see annex number 5. That the order passed by the Lana Session Judge. He has been co-accused has been granted bail. And this honorable court has earlier rejected the petitioner's prayer for bail on the ground that investigation was on. Now, investigation completed. I am in custody from 4/5/2024. 4/5/2024. And Madam has directed me to
Charge sheet filed.
yeah, charge sheet filed. And Madam has directed me to show my conduct. That means to whether I have a case. In fact, I have 2 cases and I have filed the affidavit. That is also before my lord. That 2 occasions on earlier I have 2 cases. And on both the cases, yes, my lord. In both the cases, I am on bail. And the allegation is that I was an employee of a particular person and taking advantage, I have taken the key and opened the door and taken out the money. And the time period is not there because I humbly prayed by people to appreciate. Not a case of 380. It may stay 379. Because it is a case of the prosecution. I have taken the key and get inside the house of my employer and I somehow committed the crime. So it was 379.
How much you have taken?
Around 70,000. And of the property has also been seized and from my possession and from the possession of the co-accused who has been granted bail by the honorable.
Recoveries.
Yes.
Co-accused have no criminal antecedent. That's for that, my lordship.
I am ready, my lord. They say I will appear with the police station regularly for a period of till conclusion trial.
380 case, how many years? He is already there.
4/5.
4/5.
7 months, 8 months, 9 months का पे गया, 8.5 months.
4/5/2024, he was.
Appear करियो Delhi.
Left case, how many years? Petitioner is petitioner is in custody from 4/5/2024.
24 months.
The co-accused in the present case has already been enlarged on bail by the which is the order?
Sessions Court, Annexure 5, Madam C.
Already enlarged enlarged on bail by the Sessions Court while allowing his bail application BLAPL number 217 of 2024 wide order dated 30/5/2024. Then counsel for the Mr. Charles and for the petitioner submit that the role of the co-accused retributed by the prosecution is similar to that of the present petition. Therefore, he is entitled to correct. Ms. Marana, appealing for the state, submits that the co-accused who has been granted bail has no criminal history.
Yes.
Whereas the present petitioner is involved
Two.
in
Antecedent.
2 more cases. Therefore, he submits even if the petitioner is enlarged on bail, stringent conditions should be imposed. And the consent should be imposed. Petitioner is in custody since 4/5/2024. Regarding it to the period of custody, nature of allegation, and the fact that co-accused has already been granted and plan to enlarge the petitioner on bail, subject to the additional condition that we shall appear before the which police station?
Second local police station there.
Station ये है झारसुगुड़ा झारसुगुड़ा PS within झारसुगुड़ा PS on every Sunday between 10 to 12 10 to 12 PM no? 10 to 12 okay in the morning from 10 to AM to 12 noon, 12 noon.
ମେ ଇଭିନିଂ ରେ ଲାଗେ ବରଂ ଭଲ ହବ ଚୋରଟା ଇଭିନିଂ ଟା ପାଇଁ ଭଲ ହବ ଇଭିନିଂ ଆୱାର ମ୍ୟାଲେଟ୍ ବେଶୀ
Evening hour କରିବି।
ଆଜ୍ଞା ବେଟର
ଥାନାରେ ପକେଇ ଚୋରି
ଆଜ୍ଞା ଆଜ୍ଞା ସେଇଟା ମୁଁ ସେଇଥିପାଇଁ ପନିଶମେଣ୍ଟ ଯଦି ହଉଛି ପନିଶମେଣ୍ଟ ସୁଡ୍ ବି ପର୍ପସ୍
Evening time from 6 o'clock to 9 o'clock. 6 o'clock. But 6 o'clock to 9 o'clock he is sitting in the jail. Thereafter he start his work. And, for 6 months. 6 months. The conduct of the petitioner shall be
Closely
recorded by the police. In the event the petitioner is involved in any other case of similar nature, the concession of bail granted to him shall be recalled on the application of the prosecution before the trial.
Yes.
better.
If you involve in a one.
Yes, ma'am.
Yes,
Ma'am,
ma'am.
that will better. Oblige. The Lordship says enlarged him on bail, my lord. With the condition that at the time of granting bail, the trial court should verify the antecedent of the
Yes.
So he has
Now he has
verified
four antecedents.
There is another antecedent. My another case is against this petition.
I have
But-
kept those matters, Sujata, Jana,
May not-
supposed to, no, I know, supposed to address in that issue. What will happen to 37
37 my.
bar? Simply adjourn 2 weeks, yes. FAO.
8.
Delay of 22 days, madam.
Okay.
Delay to be controlled, my lords.
Yes.
And with the lordship's permission, my lords, one order passed by the coordinate bench addressing this issue has been decided, my lords.
Yes. Yes.
Next page. Involve of DL is here, my lords. Here.
Ready?
Yes, ma'am.
Ready?
Ready, ma'am. 5 lakhs, my lords, consolidated.
5 lakhs.
Rest amount to be returned to us.
For the 5 lakhs consolidated. What was the award amount?
15 lakhs.
Award amount. You change it and give it in pencil.
Ma'am.
Same thing. What was? ठीक. Allowed. And जहाँ जहाँ change करो pencil record दिन तू. Yes.
39.
May I please, my lord? In this case, both parties present before the lordship's court. Compromise, they are residing peacefully. I filed the affidavit, my lord.
They've already appeared.
Yes, my lord.
They are here today.
Yes, I am appearing for a white pen.
Yes.
I have already been filed.
The instance of how many accused are there? 3. Total 3 accused.
Three accused persons, my lord.
3 accused.
Yes.
At the instance of opposite party number 2 and fire number 2. It is not. And for alleged offense. What is the stage? Investigation is going on.
Charge sheet is submitted.
When you have
Hangiri police station, my lord, to October 2021, my lord.
do you have the date when the charge sheet was filed?
6th October.
6th October.
Yes.
2021.
21.
After investigation, charge sheet has been filed in case on 6th October 2021 for offenses as mentioned. Mentioned. Suppose he has asked for
Yes,
2-3 witnesses,
But
then you will be in trouble.
Your lordship will kindly see the purport of.
Why don't you get instruction? Get that application. If you have the application, give me right now. Just see.
The better why he wants to examine that profile, etc.
Then if you give concession here, then you will be in trouble.
Yes, madam.
Instruction against the better.
I'll put it after 1 week. After 1 week, Mr. Bose, letter counsel for the petitioner, seeks 1 week time to place on record the copy of application he has moved under section 311 CRPC. Lease the matter on so-and-so. Interim order pass on such shall continue. Yes.
Your lordship will call it 2 weeks. Because I'll call
2 weeks, interim order to continue. Yes.
Right.
Yeah, despite notice, the non-APS for opposite.
The noting your lordship times.
Address left means
Just left, but he's protesting there as a complaint.
And
He will not implement it.
notice.
But your lordship will permit me to take a fresh notice.
Fresh notice, ma'am.
Because my-
Mr. Bose, counsel for the petitioner, further submits that despite the notice was sent to the opposite party in the correct address, the postal remark, the notice has been returned with the postal remark that the notice left.
Left.
Notice left. He submits that he would serve the copy of the petition to the opposite party through counsel before appearing for him before trial court. Trial court. Leave the matter from.
Right.
Give a copy to the counsel.
Yes,
and appeal. Yes.
42.
42, my lord. As per last order, my lordship pleases to, on order dated 23/12/24, my lordship pleases to allow me on January 10th to surrender before the land court below. But due to some unavoidable circumstances, I could not able to surrender. I filed one IA number 242/25.
For the reasons stated in the application, they say.
Which time to surrender?
Is extended up till 25th February.
February, my lord.
Due to time extension portion, chapter made clear that no further extension can be granted.
And NBW till date my captain advance.
NBW till date.
Captain advance. Obliged, my lord.
Item 43, I am appearing through virtual mode.
Yes, sir.
Yes, pursuant to the last order, we have filed requisites, but notice has not been sent. There is noting that office note, may kindly see. Notice could not be issued to any of the opposite parties as there are two opposite parties as per the cause title, but in the order dated 23/12/2024, it has inadvertently been typed out as issue notice to sole opposite party.
So what do you want now?
So we have filed one requisite.
How many respondents are there?
There are two respondents, but contesting respondent is open number one.
Okay.
Yes.
Let us call for the petitioner submits that notice to the opposite party could not be served due to want of sufficient requisites. He want to want 1 week time to 2 days time to file requisites.
One extra requisite.
Okay, you file the requisites first.
Yes. So interim order may be continued.
Interim order to continue. Yes.
Okay.
Yes. Yes,
May I
madam.
present? My lord, extension of surrender date, my lord.
Extension of surrender date. For this, yes. And no further. Yes.
Oblige your lordship.
45. 45.
Yes, sir.
That case not where I was placing the other day, because I have placed certain coal order with the opposite parties, and the coal had come in a ship.
Now, what is service position?
My lordships, I am appearing on behalf of the opposite party company.
Mistake of your briefing counsel.
No, I think they have opposite parties appearing, Maharaj.
No, but notice could not be served. You are appearing for all of them.
Yeah, all of the directors, yes.
Then you solve it. Notice, sir. She is entering it.
Yes.
Default is condoned by. Yes. Yes. What do you say, madam? Will you file reply or argue?
I am agreeing to the settlement that is being agreed to between the parties.
Very good. Very good. Yes. What is the settlement term? Shall I
And
dispose it up?
Yes, settlement annex.
Sir? Oh, file an affidavit, I'll do it.
Lordship just sees, Maharaj. Annex 2 at page 24.
2, okay. Yes. Yes.
Maharaj, we confirm the terms of settlement as up. Parties have agreed that Mercuria shall pay a sum of $350,000 to Sham. Now, Mercuria is the opposite party, Sham is the petitioner. Stage 1, Mercuria shall make payment of $150,000 through bank transfer against Sham.
You are in which stage now?
Malad, I'm page 24, Malad.
No. Page 24, I understand.
Yes.
But there are 3 stages.
They have paid Malad, the first 1.5.
First stage is complete.
Yes, complete.
That is $15,000 US you have paid.
Yes. 150,000.
150. Okay.
That they have paid and I have accepted.
You have accepted. What about the second stage?
Second is after this withdrawal, they'll make the it is compromised and they'll be paying make the second.
Sham to withdraw and terminate all the proceedings, judicial, criminal, so and so, and one before so and so. And this is the case.
Yes.
Bhadrak appears so and so.
We are agreeing, Malad, in fact.
Second by 5. Now, how many cases are there?
Malad, 1.
The C.
It's a
stage 2, the C.
Sorry, Malad.
Bhadrak stage 2 in that mail. 24, page 24 in the middle. Sham to withdraw and terminate
that GR case
all the pending judicial or criminal proceeding one pending before judicial magistrate so and so, Bhadrak, NGR case so and so, so and so.
But the complaint case has been ultimately transformed to a JR case.
Only one case there.
Only one case.
This is the case.
Yes.
Hello. Right on. Notice was issued to the opposite party by the order dated 21/1/2025. Madam, you filed Wakalatnama? Power?
Yes, 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 sir. I have filed Wakalat.
Power. Where is that? Memo you filed or power?
Wakalat, power, sir.
This. Power. Okay. Okay. Mrs. Devika Patnaik, enrollment number also has entered appearance on behalf of opposite party. Mr. Das, land counsel for the petitioner, has taken me to Annexure 2. Annexure 2 is the mail sent from import. Who is sending this mail?
This is from me, madam.
Mail from his client to
the opposite party.
The opposite party. Opposite party number?
But it is the one company, Mercury.
2 to 5 likha hai.
Mercury is one company, the officer.
Contesting opposite party. And the mail indicates that the parties have already settled the dispute. And the terms of the settlement are as terms of settlement 24. Land counsel for the opposite party who has today entered appearance today and filed Wakalatnama has submitted that she is completely in agreement with the submission made by Mr. Das. Further submits that insofar as the stage 1 of the compromise settlement is concerned, the amount of rupees USD 150 150,000 has already been paid. Insofar as the second, you have to pay the rest of the installment. The rest of the installment as stipulated in the settlement term is concerned, the same shall be paid immediately after the termination of the proceeding initiated by the opposite party against the petitioner.
Well, the payment particular is Annexure 3 also. The payment that we have received, it is Annexure 3.
Yes. Immediately after the termination of the proceeding. Hence, both Mr. Das and Mrs. Devika Patnaik conjointly pray for judgment of the proceeding arising out of FIR number so which so case for the state, and submits that the dispute basically is arising out of a commercial transaction and the parties have already settled their dispute, and the councils appearing for the contesting parties have conjointly prayed for judgment of the entire criminal prosecution. Hence, there is no legal impediment in what we say regarding to the aforementioned facts scenario and the submission made at the bar. I am inclined to allow this petition accordingly. So request. Yes.
JR case number 3. That's in the prayer, page 11.
Prayer
11.
There is no problem in the prayer. Yes.
Obliged.
Yes.
Applies by lordship.
May I please, your
Yes,
Lordship?
sir.
Lordship, kindly see the petitioners before Lordship are facing the prosecution, where the allegation is that they 412 of IPC is attributed to them as per the allegation. Basing on the confessional statement of some co-accused, after 2 years, my lord, the case is registered. Though initial case was registered, but these accused persons are dragged to this case under section 412 IPC, alleged to have recent stolen property arising out of Dokaiti.
Yes.
The case is that FIR was lodged before the my lord in charge Kanjipani PS. The owner of the truck stated filed that the helper and driver was carrying certain loaded aluminiums. The can you see page 11?
Yes, I'm
yes, I'm just permitted to
Yes.
Your Lordship, candidates. First paragraph is the, my lord, the Karan Jetty, aged about 25 years, back to registration number.
Second paragraph, the helper
Somewhere managed to escape from a clutches of the hijackers and reached Bisui Thana, Mayurbhanj, early morning on 20th of August 2024 and informed me. Accordingly to the helper, named Ranas Beshan, while traveling through Kanjipani Ghati, one Scorpio overtook my vehicle at about 10 p.m. on 19th of August 2024, or some 6 to 7 people, some 6 to 7 people came out from the Scorpio and started beating the driver named so-and-so Saha and the helper, and they kidnapped them along with the vehicle. After traveling certain distance, they threw the driver out of the Scorpio, and then driver certain distance threw the helper out of this vehicle, from where he reached the Bisui Thana, Mayurbhanj. The above mentioned vehicle was loaded from Hindalco Industries Private Limited, Hirakud, Sambalpur, and was going to Hindalco Industries Private
What is
Limited.
recovered from you?
Yes, nothing. That is why, Miller, 412 is not applicable. Also, the 114 of evidence at presumption. If nothing is seized from my possession, and kindly, interestingly, my lord, see, the police recovered the vehicle along with the materials. This is the case. I may permitted to place. During course of investigation, I examined the complainant, visited the spot, examined the other witnesses, recovered the hijacked truck from the nearest Jaleshwar by the side, and along with the loaded aluminum truck ingots. I am from the Calcutta. I am a Millard owner of a plant where Millard nothing.
Yes, yes, sir.
I'm just
What is recovered?
2015 matter. Now.
Once is not 412.
112. Receiving stolen from.
Not.
No, that's what anything is recovered from him.
This is the ballot certified copy. I'm just one line.
See, the problem is you have also not filed anything except one page of charge sheet, which is nobody in the earth can read it.
Kindly just I'll file it in shape of the affidavit.
That's the problem.
I'll serve the copy and I'll file this.
And
this is the case.
The position scan copy of this you have filed, not to be.
I'll file it in affidavit. I'll file it.
Type it and file it.
Yes, I'll type it.
And just get it. If nothing is recovered, where is the question of 412?
It must be the section 412 still receiving stolen property.
2009 is the FIR.
Yes.
And thereafter.
This case is pending from 2015.
And he has been made the accused. Unless you have recovered something.
I'm taking instruction.
Co-accused might have said that I have sold it to XYZ. But unless you recover any connecting evidence.
Admitted
property is
that is separate things.
Okay.
2 weeks.
2 weeks, after 2 weeks. 2 weeks. Continue.
So 412 is not there. Once loaded truck and ingots.
He'll find out.
Yes.
If nothing is there, he himself will tell.
Yes, I will have the copies for his perusal and instruction.
Yes.
Obliged.
Sir, may I please lordship?
Yes, sir.
But lordship, may kindly see flag A. The petitioner number 1 has died on 21/6/2023.
Flag A.
Flag 1, my lord. Sorry, flag 1. The petitioner number 1, Krishna Chandra Sandil, he has died on 21/6/2023. Death certificate I filed, my lord, along with the memo. Now, my prayer is confined to the petitioner number 2, the wife of the petitioner number 1, my lord.
Okay.
But the OP number 2, my lord, initially, he filed a complaint case, alleging that my husband took 8 lakhs rupees from him in 3-4 occasions, and thereafter, he executed a notarized agreement to sell a particular piece of plot to the OP number 2. Thereafter, my lord, your lordship may kindly see.
Who is appearing for opposite party number 2? Just
Mr. Mahanti, Abhishek Mahanti. Last occasion also did not ask not later. Totally civil in nature, my lord. And your lordship may kindly see on that day, the date of allegation is that.
I'll just pass it over. He may come. I'll just.
Your lordship,
pass it over. Yes.
48.
Yes, madam.
Yes, my lordship, I'm appearing in person, my lordship.
My lordship, last time the instruction was obtained for 3 cases, my lordship.
Have you
That
served
is
the
annexure,
party number 4?
annexure 4.
Appearance in Market before question of party number 4.
Yes.
Along with
Yes.
Prayer has been made for quashing of the affair. My lordship to consider whether the affair can be quashed from the threshold or not, whether prima facie material is available or not. That is to be seen. Only prayer has been made to quash.
What is the stage of
Investigation is going on. So direct to complete the investigation. There is no material, then final report will be submitted.
I believe all the parties are related.
Yes.
So that is the reason I issue notice. Is there any chance of settlement?
No, there is no part of that in my instruction. There is no settlement. Because dispute arose with regard to possession of a house. And suit is pending between the parties. Before the court. Yes. There is a registered will.
He is claiming the right over the property.
Yes, that is the
And
property.
you people are in position.
Yes.
My lordship, the will number which they are stating that is not probated, which has been rejected by the Tahsildar. And therefore,
All these things will be decided in the suit only. I can't decide it. Now, just investigation has now begun. We don't know whether any case is made out or not. So let the investigation be over.
But last time, my lordship, annexure 4.
I issued notice because there is a chance of settlement.
That is, yes, my lordship, but before that also 3 cases status has been obtained from the state.
How many cases you have filed?
One is 302 in Chhatrapur PS, file number 42.
Mistake of fact, she died in Corona. That is there. Everything.
My lordship, where is the dead body?
This present case is
If died in Corona,
time, you know how the body.
No, my lordship, after that they have made the document has been made, my lordship. Initially, when I went, there were no patient.
Have you filed protest petition there? Have you filed protest petition?
No, my lordship.
You filed protest petition if you are not satisfied.
Because it was under investigation if it
No,
has
they say that it is now closure report has been filed that your father died because of the corona.
Okay, filed the-
You have not done anything.
Then I will file the protest petition. Now I know that.
No, I just wanted because so many litigation and all. If there is a chance of how many houses are there?
Only one building.
Only one.
Yes.
2-story building, my lordship.
2-story building.
2-story building.
You are in
And-
possession.
Yes.
How are you related to her?
Uncle.
Why don't you pay something and settle the dispute? What is this?
My lordship, after death of father, they are forcefully they want to take
After all, he is
possession
the
because
doctor of his daughter.
and one daughter, and we will take the property. That is their intention, my lordship. They have killed my father. my lordship.
Don't fight on
Lost my
technicality.
father and also
See,
property they are grabbing, my
Other
lordship.
perspective, you see, her father has died now. Her father was your brother only, own brother.
Yes.
Isn't it? He is entitled to something. Why don't you pay something and finish up all this? What is this? She has been filing case after case against you. You are filing case against her. She is alone. What is this?
This is the position. I don't know.
I advise your client to settle it. That is the reason I have issued notice. Always better that you should do it. Shall I put it in the mediation cell? You persuade your client. Pay something to her. She is now started practicing. She has to, settle in her life.
I will obtain instruction whether the lordship take it to court chapter so that I can obtain instruction whether there need.
No, you have to advise them. You have to advise them. If they fight with on their own knees like this is not fair.
Dispute we are around since long between them.
So that is the reason I am saying either you dispute, otherwise something is
498 case is pending.
498 file by
Mother, my lordship, they were in custody. 3 years they were in custody, my lordship.
Yes.
They have put kerosene and
everything
tried
is
to
revolving around that property. All cases, counter cases, everything is arm twisting method only for that property.
Yes,
Simple.
my lordship. They have
498,
my lordship,
02,
they have
everything.
theft of the articles also, my lordship. Even vehicle also they have theft, my lordship. Two theft case also they are pending, my
Madam,
lordship.
you better that you concentrate in the profession,
My
settle the issue, take some money and finish it up and concentrate in your profession. Why are you filing cases after cases?
Oh, my lordship, my
You
lordship,
lead
I
you
am,
nowhere.
my lordship, I am one.
You are a good advocate. You why don't you do it?
My lordship, only one. For that only they are harassing.
I can
They are
only
harassing,
suggest
my
you. I
lordship.
can't do better than this.
Forcefully they are taking me, putting all the antisocial persons and forcefully entering the house and grabbing the property, my lordship. ROR is in my name. They are coming inside and
Shall I
grabbing
send
the
it to
property, my
mediation? You
lordship.
seek instruction. I'll put in next week. And you impress upon them to settle the issue.
If they are interested for settle, I will obtain instruction and also keep it on 4 weeks so that I can obtain.
2 weeks.
Thereafter,
2 weeks after. Okay. Yes. Yes.
49.
So this application for passing the proceeding initiated by the daughter-in-law under section 498A against the parents-in-law who are more than 75 years old. If you also look at the FIR,
notice was issued.
Notice was issued. They are staying in London. They are awaiting notice. Both wife and husband, my son and my daughter-in-law, they are hand in gloves for the property. Wife lost the FIR, went back to London. Now old parents are suffering.
What is the stage now? Cognizance is taken.
Cognizance is taken. If you also one document I will show to your lordship, page 30, Annex 5. At the behest of district legal authority, welfare committee inquired into the matter. The finding of the committee.
Yes.
Page 30.
Yes, I'm there. Opinion of the committee.
Opinion of the committee.
After having.
Yes, after several records, meetings and documents came across various evidence, out of which some audio recordings were also presented before the committee. After listening to it, the committee found that there is a conflict between the parents, that is husband and wife, and in-laws.
One side
and the other side.
In-laws and
other side.
Due to property
in-laws. Our property in-laws. The allegation of dowry demand is false. Even the allegation.
What do you say?
Again, London reaction they are still going to say. And also you have been pleased to notice twice, Millers.
That is there. Now somebody.
Khandagiri, you have given the address of Khandagiri. Portia.
Yes, it is. Now they are staying in London, where old parents who don't know where they are staying. They are not responding. They are not. My son is my daughter-in-law. So
I'll definitely quash it. There is no second opinion about it. But I just wondering whether the opposite party number 2 is staying in India or.
No, she is staying in London. That is because the
you have given the address of Portia.
No. Report is they are staying abroad. When the notice is being served, the report is that.
Where is that report? Show me the report. Report.
Postal report says they are staying abroad.
But you have given Khandagiri address. What to do? Let's see. Let the opposite party number 2 be served to the IIC. Which IIC? IIC of which police station?
Import City Police Station.
Import City Police Station. Within a week, lease the matter on. Let us complete the formality.
Yes,
lease the matter on 4th February. And you get a report if they are staying abroad. Place it on record so that I record it and quash it. Entry mode to continue. It is made clear that no further adjournment shall be granted. Yes.
50.
The petitioner lordship seeks to assail the order dated 36/2020 2020, passed by the learned JMFC Bhubaneswar Lordships, wherein cognizance has been taken under section 380 and 454 IPC.
Yes.
Fact is like this, Lordships. In the year 2018, an FIR was lodged. And the FIR was lodged against another person. He was the one Gunduri. It was lodged against was Gunduri. And it is
informant.
Mediation has failed. It was lodged against one Gunduri. And then charge sheet was filed in the year 2020 against the present petitioner. The story is like this. The informant alleges that the petitioner, who is the neighbor, he entered the house and stole certain property. The FIR was lodged against the milkman, stating that the milkman had entered and taken the property away. And then after the first 161 was completely in favor that the milkman had entered, taken the property, opened the door, etc. After about a year, a second 161 report was came across, wherein the allegation it shifted towards the present petitioner and her brother. This is the basic fact. They say that we used to leave the keys in the house of our neighbor. All the good for good and bad time, she was always there.
What have you stolen?
Stolen, Your Lordships, some jewelry, I guess.
Jewelry item.
My prisoners. What happened?
They are your neighbors. You used to give them the key of your house. And whether the milkman has stolen of you.
Taking advantage of that, my lord has stolen the items.
What are the items?
10 gram of golden jewelries, 10,000 cash.
Jewelry or jewelries?
Jewelries.
Two gold necklaces, Your Lordships. 2 gold necklaces, 2
10
chains.
gram. 10 gram.
34 grams.
34 gram.
2 gold chains, 10 grams. 1 gold Mongol Sutra, 10 grams. 2 gold rings, 8 grams. 1 gold ring, 2 gold earrings.
Anything recovered from you?
No recovery.
Anything recovered?
No, Your Lordships. As I said, 2018, the direction of the investigation was towards the milkman whom they had alleged. Nothing could be recovered from them. So 2019, the investigation turned towards me and I was implicated.
What happened, my lord?
And that is it is there on record also. Of course, I have not filed the charge sheet. I should have, but I have not.
Let me clarify, my lord.
Yes.
What happened? As a goodwill, I have not lodged a complaint against her.
Then why have you taken the name of milkman then?
No. I have not taken the name. I suspected he might have the culprit as he gave the milk to my neighbor. But when I saw that he was with my neighbor, but the lock was open. Door is open. The lock outside was opened by the key. Then it presumes that key was with the neighbor and she might have done. In accordance to, I think, log the FIR.
No, you tell me, can you prosecute someone and secure a conviction on the basis of might have done it?
No.
Because I have given the key?
No.
What are the evidence you have?
Yes, that is the.
What are the evidence? Recovery is not there. 380, how will you prove? Recovery is not there.
Test is there, my lord. Polygraph test is there. After polygraph test, the police found they are the culprits.
Polygraph test is there.
Yes. Thereafter, they have been charged.
Polygraph test is there.
Yes.
Nothing came across on that, Your Lordships.
Yes, I am
It is
reading out.
Lordship, let them please.
Show me the polygraph. Where is that statement?
Pardon?
Lie detection statement or test report.
Once.
Lie detection test report. Where is that? Polygraph test report.
Polygraph test report I have not brought, but
That is the only linking case evidence. If you can find out something, and that would be at best a confession. That would be at best way confession of accused.
Direction may be issued to police. I usually produce this.
I filed the entire charge.
Give me one copy.
See, if the polygraphy test is done, that would be at best a confession of accused. Apart from that, what evidence you have? Why should they face the trial? You can't secure a conviction.
No, my lord. What happened? All the suspected accused and the present accused all went for polygraph test. And the suspected out the male man has the exemption. After the test of polygraph, they found that they are the culprits, and thereafter charge sheet was filed. If they are not involved, prior to that polygraph test, they have filed the petition of 438 before this honorable court, and they have.
So the police might have called that because merely because they filed a 438, therefore they are accused.
That is not the.
You file the charge sheet. I suggested you to settle the dispute. Unnecessary. They are your neighbor. Why unnecessary? You are not going to secure conviction. You will not get conviction in this case.
Let them face trial.
There is no evidence at all.
Yes, all the evidence are there.
What evidence?
All the 161 in 161 statement, it is all the witness has said.
You have said that milkman has taken, thereafter you are turning it.
It is suspected.
Anyway, you just file the charge. Entry mode to continue.
Touch.
Let it continue.
No pressure. Yes. Entry mode is to continue.
Yes. Entry mode to continue. Yes.
Charge is 24 charge. Charge is
It's all right. You file the entire document. You should have filed the objection. Whatever evidence you have, you just see. Yes.
51.
Challenges the order of cognizance dated 17/2023.
1 minute. So
taken by the JMC in Rampur.
1 minute. The petitioner and your other witnesses were subjected to polygraph test. Release the microphone to entry mode to continue. Yes. Yes, sir.
Well, the order of cognizance dated 17/2023 passed by the JMFC Rampur in 160 number 4 of 2022, where cognizance has been taken against the appellant without sanction of the government. Now, my lord, in the pendency of the Cherlim's application, a compromise has been made between the parties, and both the parties have compromised.
The complainant, my lord, I have filed affidavit.
Affidavit has been filed.
Affidavit is flag B.
What are the offenses?
Offense is 294/506.
307 is there. 307 is there. Huh? Where is the charge sheet for me?
No, my lord. Offense cognizance has been taken.
Where is the cognizance order?
My lord.
Cognizance order?
This is the cognizance order, my lord.
Lordship, page 46, my lord.
46, sir. Yes.
Lord counsel, but the complaint is present. File Sajira, the case record stands.
1 minute. 1 minute. 46. Yes.
From the superintendent of police, Kalahandi, Varipatna.
294, 323, 506, 182, 34.
My lord.
Yes. Yes.
Yes, ma'am.
323.
But here is charge sheet is filed under 341, 323, 325, 307, 390.
No.
That cognizance page 46.
Charge sheet is a different case.
Yes.
That charge sheet has been filed.
Your lordship, that is.
It is a complaint case.
This is a dispute between advocate and
police officer.
Right. But what are the offenses you want to?
294/506.
294.
506.
506.
Cognizance order.
My lord,
Page 46.
and charge sheet which I have announced, my lord, that is the case where arising out of that final form, while the petitioner was discharging his public duty, the complainant came and created disturbance. That's why I have filed the charge sheet.
He is not able to comprehend what is the facts.
294/506.
An FIR was filed.
Yes, Lord. That is
And thereafter the
entered the police station and advocate was stolen by the IAC. Thereafter, advocate filed in 160 case before the NHDM. NHDM was to cognizance. Thereafter, the case is proceeded. The my guardian friend is saying that there is no order of sanction. There is the IAC just discharging public duty. Meaning during that time, there is compromise and there is compromise. Yes, Lord. Yes, Lord.
Who is the informant here? Opposite party number 2. Opposite party 1.
Only
This was complaint case, my
Sole
lord.
opposite party.
sole opposite party.
And Petitioner at the instance of opposite party, sole opposite party. The state has not been made party.
No, man.
Sole opposite party. ICC case number 4 of 2022. 4 of 2022 for a commission of offenses punishable under section so and so has been registered against the petitioner. The court below as by the order dated 17/4/2023 has taken cognizance of offences punishable under section court below JMFC Rampur by the order dated 17/4/2023 has taken cognizance of offences punishable under section 294/506 IPC against the present petitioner. Against the present petitioner. The present petitioner has you have filed this petition on compromise or something else?
No, my lord.
That was
During pendency of this petition, compromise was entered into.
No, the petitioner has essayed the order dated 17/4/2023. 17/4/2023 passed by the JMFC Rampur in ICC case number 4 of 2022, where the cognizance of offences punishable under section 294 and 506 has been taken. The notice was issued to the opposite party in the present case. So entered a case. Where are where are the petitioner and accused?
I have sent a link appearing from the VC, I think.
They have to appear. If it is on settlement, on merits, then it's set up. Where is he? Siras Kumar Padi.
Sir.
And Jitesh Kumar Mahapatra.
He is the
Siras Kumar Padi is the petitioner, my lord.
petitioner. Okay, he's the petitioner who is working as what? What is he? Working as? SI, a police posted in Rampur police station. He is present in the video conferencing mode and represented by his counsel, identified by him, and has filed self-attested copies of the Aadhaar card to establish his identity. Where is the opposite party?
I have informed my lord.
Opposite party has to be there. Tomorrow I will come and make allegation against you. I have not said. He has to be there.
By 2 p.m. I have already informed and sent the link.
We don't know. And so also appear. Opposite party number 2. Opposite party, sole opposite party is also appeared through video conferencing mode. Represented by his counsel, identified him. 2 o'clock he'll let him appear.
Mine.
Identified him and so on. Both the petitioner and the where is composite? Where is the affidavit?
Flag B, your lordship.
Flag B.
B.
Both the petitioner and opposite party have filed a composite affidavit dated 23/12/2024 inter alia stating as under one. Regarding Mr. Monty appears for the state and submits that the dispute is minor in nature, and the opposite party is the practicing lawyer. Opposite party
of Emrampur Bar Association.
Practicing lawyer, whereas the petitioner is a police officer. They have settled their dispute and filed affidavit before this court. Hence, there is before this court, and the allegations are minor in nature. Therefore, there is no legal impediment in causing the file. Regarding we have to say and 2 o'clock I'll
2 o'clock.
Let him have.
Item 53, lordship. In fact, lordship, already mediation already failed, but in the meantime, that girl already been married, lordship. So we have talked each other, lordship.
On behalf of Mr. Chutra,
What a
the
date
mediation
the settlement नहीं पा लगा बाहर.
mediation failed.
Now you're challenging the order of my lord, dated so was refused for 173.
Okay.
Keeping in
I'll just, what I'll do is I'll simply adjourn interim to continue. If something happens, you tell me.
Lordship, sir, short date, my lord. Now the
Yes.
trial has been stayed, my lord.
The council for the parties submits that
Naturally.
53. Conjointly submits that the mediation was not successful and the matter needs to be heard on minutes. Lease the matter on phone, so interim or to continue.
May fix a short date, my lord. Now the
Short date, short.
Yes.
Item 54, adjournment.
54. 54 is just request of Mr. Naik. Okay. Mr. Naik, Bishop Naik, Learned Council for the petitioner seeks an adjournment on the personal grounds. Lease the matter also. Yes.
Item 52, lawsuit. Lawsuit claims on adjournment lawsuit. An interim order is to be continued. Since the matter was referred to the mediation secretary lawsuit, so opposite party number 2 is not fully cooperating a lawsuit. In the last order, a lawsuit is directed to send the 10,000 rupees draft to the opposite party number 2, and we have also deposited the same lawsuit.
No, not that they've deposited, there's some pursuant to lawsuit direction they paid, not that they've shown some mercy, but
A
we are.
lawsuit is deposited a lawsuit.
Yes, I
Whether mediation is going on or not.
Yes, mediation is going on, but the opposite party number 2 is not fully cooperating a lawsuit.
Cooperating fully or
Then
partially, or is that
mediator will file a report.
Yes.
So let's see.
Yes, sir.
Mediation process is still going on. Still going on. Awaiting mediation report. Release the matter on phone. Interim or to continue. You 61. 61 to be? Why do you appear in that I'll not take it?
Item number.
Only tell the positive thing. If you want an adjournment, that is positive.
No.
Yes.
Very important, my lord.
Otherwise, we'll hear. Yes.
Item number
Adjournment
59.
59.
I am for the respondent. I pray for 1 week time, your lordship.
I was supposed to sit in the full bench, which has been cancelled. So I can come. That is the reason. Yes.
15
Yes.
for the respondent, your lordship. Your lordship, I pray for 1 week time, your lordship.
But who is appearing for petitioner? Interim order is there?
No interim order. But
So-
let it be taken after lunch.
Yeah.
Let him come.
That's better idea. Yes.
In the improved pay order, your lordship.
The condition of one that is the proportionality of license for release of non-holder of vehicle which is entirely if fair number for the allege offenses 9
Owner of the vehicle. And you are not an accused.
No, your lordship, I am not in the accusation.
Owner of the vehicle. And he is not an accused in the case. The case. Simultaneously, a motor vehicle claim was also lost by the victim. And the said case has been compromised by the order dated 9/9/2023. This court, while allowing MACA number 381 of 2023, has fixed a consolidated compensation amount of 5 lakhs to be paid to the victim. To pay to the victim. Paid to the victim. The counsel for the Mr. Janna, the counsel for the petitioner submits that the condition imposed by the court while releasing the vehicle for deposit for furnishing the property security for 25 lakh is harsh. Unable to meet the same. Hence, is symbol for this court regarding that to the facts and circumstances. I'm inclined to modify the order. Where is that order? Order dated?
This order, your lordship, 28/9/2020, your lordship, 11, page 11.
28/9/2020, passed by the Sessions Judge Jharsuguda. A 20 order, you have not taken the vehicle so far.
No, Your Lordship, no, Your Lordship. If Your Lordship, I have taken, can I approach Your Lordship to 2024, Your Lordship?
Although the order was passed on 28/9/2020, but because we could not arrange the property security, the vehicle is not released as yet. The vehicle is getting damaged, day by day. Hence, he approved this quota, moving application for modification of the order. Regarding head to the facts and circumstances of the case, the order dated 28/9/2020 is modified. The petitioner is directed to produce property security of 5 lakhs.
3 lakh Your Lordship say, Lordship 3 lakh. Property nahi hai. 3 lakh ho ji Lordship. गाड़ी टा तो गला नहीं कुछ.
3 lakhs, 3 lakhs, 3 lakhs. And vehicles will be
Instead of 25 lakhs, Your Lordship.
Instead of 25 lakhs. And the rest of the other conditions shall be complied by the petitioner while releasing his vehicle. Yes. Hello.
Due obligence, due obligence.
Yes.
24.
Yes, sir. Yes. Yes.
Yes. Para 100. I mark back mark.
This judgment is already referred to. This judgment has already been referred to larger bit. Yes.
Okay, larger bit जाइए तो आप पर भी 3 judgment हिस्सा लें 500-600 पेज but 8 point up
I know because this is regarding 45.
Correct.
45. Yes. Yes. 109. Yes. Tersely. Yes. 109.
109. 109.
Tersely put. What do you want to say from here? That's that principle is there. If you are generated by discharge, passing, total, whatever, and the PMLA case will be dropped.
That belongs to the court has to also give a finding that the property acquired is not proceeds of crime.
How that will help you?
But here, now investigation is on in respect of schedule offences concerned. So my disproportionate assets is 136%. If the Honorable Supreme Court has come to this extent, if the person in a PML schedule offences, if he will be discharged and finally acquitted or quashed by the Honorable Court, so there will be no proceeding under the PML Act.
It doesn't say.
Malad? That is also line your lordship. Last sentence also. Last sentence also very important. Taking any other view would be rewriting of this previous and disagreement expression language and definition clause proceeds of crime. We can't take other view also.
We'll examine, but I don't think
PMLA has no leg itself. He's depending on schedule offense.
This judgment itself says that it is an independent proceeding. But it is contingent upon outcome of the schedule offense.
Lordship, no.
Logically, you are 100% correct.
Your Lordship, 148.
148. Read it. Next question.
Whether
the offense under section 3 is a standalone offense?
Yes.
Indeed, it is.
The answer is there.
It is dependent on the wrongful and illegal. the property as a result of criminal.
That is the answer 148.
That's right. There is no quarrel on that.
Well,
But where is the legal bar that it can't proceed independently? It has to proceed independently. It is contingent. Even if you are convicted in PMLA, ultimately in the schedule offense you are discharged. Then
but I will be convicted. I will be convicted in the PMLA Act. I will be in custody. Whereas my schedule offense.
That's the whole difficulty. That is not addressed by the court.
That is the entire case.
But that is not addressed by the court in this.
Yes, no, but this is the.
This is the.
Which one?
281, 282 and 284.
This is the only judgment I produced. I'll produce other judgments of these various high courts.
Why are you bringing insolently? You come on.
This is here. I am raising a point. Not.
That's right. Your point I am well taken.
Your also kindly see this. Here that quote that has been quoted. It will be very clear.
Yes.
Your also kindly see. Here, Vijayanandana has been quoted.
Yeah.
Here, Lord, simple offense was passed in the present case. But subsequently, another FIR, that FIR was subsequently transferred to the SFIU. So once FIR registered, court said no, it cannot be. Lordship, kindly see paragraph 30.
But that is separate issue. That is separate issue.
38. Yes.
That is a separate proceeding. You have a.
So there is a multiple ground.
Yes.
Undisputed fact between the parties are that the FIR has been registered and such by the Central Bureau of Investigation under section 120B, read with section 420, 467, 468, 471, read with section 32, 31D of PCL 1980, based on the schedule of offense. Economic case information report was registered and the investigation was commenced. It is not in dispute that complaint under section 44 and 45 of PMLA had been filed. Thereafter, supplementary complaint was also filed revoking section 447 of the Companies Act 2013 on such as that. The FIR was challenged before the High Court of Karnataka. The High Court quashed the FIR on the ground that the investigation pertaining to the same allegation against the petitioner and other accused was entrusted to Serious Fraud Investigation Office. And the SFI, after investigation, submitted a report and thereafter filed a charge sheet complaint before the special court, and the same is pending before so and so. Therefore, the court quashed the FIR number so and so on the ground that SFI alone has jurisdiction to try the schedule. Then paragraph. It is pertinent to note that in respect of other active persons, the FIR in predicate offense still in force. Here is also the FIR is in force. And it is also to be noted that SFI complaint still stands good. So SFI complaint was registered on 28/3/2009, much before registration of FIR by the CBI on 1/11/2009. And ECIR dated so and so. Meanwhile, the CBI has preferred an appeal against the FIR passed order passed in favor of the petitioner in the time limit before the FIR was passed. The enforcement directorate investigation process was conducted and a supplementary complaint was filed in the year 2024. Then you also kindly see para 60. During the pendency of a serious fraud investigation office proceeding, which is scheduled offense, it is jurisdiction to enforcement directorate to investigate the matter, and the ECR cannot be stated to be without a predicate offense. Therefore, the proceeding under section 447 of the Companies Act 2013 is a scheduled offense under PMLA 2002. You are then para 18. Therefore, the action of respondent department does not stand designated as the predicate. Now you are also para 20. After investigation of crime, respondent department has to investigate into whether the offence has been stated under section 3 of PMLA has been committed or not, and the adjudication, prosecution, and trial under PMLA is independent of the schedule offence. The respondent is the notified investigating authority for PMLA only, and not for the schedule offence. Both the proceedings are independent in nature according to the scope of the act and also to dictum of Honorable Apex Court in Vijayanandana Chaudhary case Supra. Then para 269 has been quoted below. From the bare language of section 3 of the 2002 Act, it is amply clear that the offence of money laundering is an independent offence regarding the process or activity connected with the proceeds of crime, which had been derived or obtained as a result of criminal activity relating to or in relation to schedule offence. The process or activity can be in any form, be it one of concealment, possession, acquisition, use of proceeds of crime, as much as projecting it as untainted property or claiming it to be so. Thus, involvement in any of one of such process or activity connected with the proceeds of crime would constitute offence of money laundering. This offense otherwise has nothing to do with the criminal activity related.
No, that's very important. This offense is
Yes.
otherwise has nothing to do with the
Yes,
criminal
Lord.
activity relating to the schedule offense.
Yes, Lord.
Derived and obtained as a result of the
Yes,
crime,
Lord.
except the process of the crime, derived and obtained as a
Here,
result.
Lord, admittedly, proceeds of crime has been found. 2 crores some odd has been found that more than to his known source of him. So he is to now, under section 24, burden is on him to say, no, this is my
Who is investigating that predicating offense?
vigilance department.
Vigilance. Vigilance department is a party,
No, vigilance department is
not a party.
Then the para 281 has been quoted below, para 281, 281,
My
281.
friend-
What is the stage of
What my
investigation?
friend is making, sir.
Stage of investigation,
No, but
schedule offense.
Recently, there is a judgment has come by the Honorable Supreme Court on this point only. Till the investigation is closed or till conclusion of schedule offense, the judgment in PML has to be stayed.
Where is that use? Why don't you give those judgment? You are bringing such a big judgment that will not help you.
This is the first.
That's right, but where is that judgment, direct judgment, where it says that the PMLA case can't proceed
Yes.
till it is.
I'll produce that judgment. I'll produce that judgment. There is a direct judgment of the Supreme Court, what my friend is making. That is in the live law. It was there in the live law. Recently, it was in the live law. He's very much aware of that judgment.
Nothing to be surprised about it, but where is that judgment? I'm asking you. And everybody, it is not supposed to known by everyone.
No.
You might have.
Live law atlas. I'll produce that. I'll give that.
Then when? Tomorrow?
Tomorrow, day after tomorrow, any day, Lord, I'll produce that.
Tomorrow.
I'll produce that. Direct judgment of.
Show me direct judgment. This will not. You are logically absolutely correct. I'm not on that.
Say more mundu strike
There is a point to be.
Yes.
Let us examine it. I'll just issue notice. I'll issue notice, examine it, and you move application for adjournment. Let us issue notice.
If your lordship will stay the framing of charge,
No, I'm not framing. I'm only moving application for adjournment.
And
Next week.
if that will the court will not frame the charge, if your lordship will make this observation that the court will not frame charge. Your lordship make it clear that the court will not wait for framing of charge.
Order
I can understand.
impugned order again, he is the counsel.
Your discharge application has been rejected.
Again?
Your application under 227 has been rejected.
Yes.
That's right.
Now, the next day, court has directed to appear in person, failing to issue NBW.
No.
That I'll cancel it. Don't worry. When was the order? When was the order of discharge?
At page 102, court has not said so.
When is the order passed?
Order 18th below.
2023. Now you are coming in tomorrow. No, simply issue.
A petition with order.
That's right, but 2023 the order was passed.
23?
No.
24 below.
2024.
Which page? Which page?
Page 95, page annex 5.
95.
Page 95. 18/11/24.
Oh, November it is 5.
On the last moment is.
Oh, day after. Keep it day after. Come with day after. Okay. Issue. Simply issue notice day after. Yes, next.
Item 51.
Day after. What can I do? Only 3 months you waited. There is an opposition.
Nothing will happen in one day. If adjournment will go.
Here from 18/11.
If there is no opposition, I could have done it. If there is serious opposition, what to do? 3 months you waited.
Quebec case.
Okay, when have you filed?
Case.
No, when have you filed the petition? Let us see. When have you filed the petition?
Well, I have filed this petition on discharge 921, page 921.
No, when have you filed the petition?
7/11/2024 पास कर नहीं कौन 7/11/2024 रे फाइल कली से 18/11/2024 रे ऑर्डर कर ले तापर ओडे पिटिशन कर जगह से ये दोनों तो आया
No, you are filing on 24/1/2025.
Again?
24/1/2025. You filed the petition. See, come to page 28.
Then E482 application. हाँ इटा तो मैं
I
file
waited for 3 months.
ना
and
ना कहीं कि मोरे petition दिल्ली जाए आगे stay करे पे till माने completion of
This is
investigation.
not the story.
That petition has been rejected. That's why मैं आसिली.
Otherwise, you would not have challenged.
आसिल तो सत्तर है जब सेटिस मैंने stay करी था तो मैं आस्ता नहीं कहीं.
Oh, this is for stay, not for
नहीं
challenging.
मैंने I take all sincere steps कि मु सेठी ଗୋଟେ petition देली show करेली जे आगे Supreme Court कहचंदे you wait till
Where is that petition?
that again order टा तो अच्छी.
Where is that petition and show me the order? If there would not have been opposition, I can understand. If there is opposition, what to do? You have to substantiate a case.
ଗୋଟେ time ମାନେ ଗୋଟେ adjournment ନବା ପାଇଁ ଯଦି oppose କରିବେ ମୋର ଆଜ୍ଞା କିଛି କହିବାର ନାହିଁ.
Day after tomorrow, I am keeping you. Tell the court that matter is fixed tomorrow. Yes. Next.
47.
One more. Sorry, yeah. That item 63.
Yes.
Sorry, yeah. Yesterday, I received the result. Yesterday only, as a discussion.
No, I rely upon their counter affidavit.
That's true.
There are 3 judgments he has cited, except 40. I have filed all the judgment. I rely upon their judgment.
That's I admit without, but I could not.
But moral of the story is not prepared.
Actually, I came yesterday night.
I can understand the private lawyer asking that I want instruction. But he is asking for instruction.
I could not go through the
Material instruction is necessary for a private lawyer.
The
not-
material instructions are will get.
Now he changed the gown, then he is entitled now.
Sir, will get.
Can I? When you
Every day I ask you next to class.
You just tell me whichever date I'll fix.
can it be 5th?
5th, okay, no problem.
Because 5th we are having Delhi election, we have to declare holiday.
Okay, 5th. Ready to be on 5th.
Can I have it on 5th?
Yes. If he has no problem.
If he ready, I am ready, my lord, with the matter. 5th. Much.
Okay, 5th. Same arrangement. Same arrangement. Okay, 5th, yes.
Much obliged.
Interim order.
Interim order to get.
Nothing, there will have oppose there.
My lord, flag 1, my lord. The petitioner number 1 has died on 21/6/2023, my lord. Death certificate I have filed, my lord. The criminal case as such is abetted against him. So the CRLMC is now confined to the petitioner number 2, who is the wife of the petitioner number.
I'll just write it first, sir.
My lord.
Learned Counsel, the petitioner submits that the petitioner number
1, my lord.
Krishna Chandra
Sandil,
my lord, has expired on
21/6/2023.
And 21/6/2023, and death certificate has already been placed on record. Therefore, he submits that insofar as the present petition is concerned, the same is not the same is being pressed for the petition number 2 only. Yes.
My lord. My lord, the OP number 2 filed a complaint case before the landed magistrate stating that my husband had received 8 lakh rupees from him on several occasions, and accordingly he executed a notarized agreement that he will sell a particular piece of land to him, my lord. On 14/1/2012, the OP number 2 came to our house, and I, along my husband, scolded him. But your lordship may kindly see annexure 4, my lord, page 35. On 41/2012 at 9:19 a.m., my husband was hospitalized for administering chemotherapy. He was a cancer patient and died of the disease. And in the complaint petition, he has stated that on 41/2012 at 10 a.m., he came to our house and we scolded him. The allegation against me is that I, along my husband, scolded him, abused him.
Where is that?
My lord.
Timing, let us see the timing.
My lord, the complaint petition.
Page 35, timing is?
My lord, page 17, your lordship may kindly see. That is the complaint petition time he has given. Page 17, paragraph V, my lord. That the complainant, along with his 2 staff, namely Tareknath Ganguly and Sanjeev Kumar Mahapatra on 14/1/2012 at about 10 a.m. went to the residence of the accused persons and requested them to execute a sale deed in respect of property described above or return the amount which was taken by them. But the accused persons flatly denied to return the amount taken by them and sold it in favor of the complainant, and accused person further scolded him, saying this and this. And the preceding paragraphs, my lord, all against my husband, that he took 8 lakhs rupees on several occasions.
8 lakh rupees you have paid?
No, my lord. I have not paid. He has given us 8 lakh rupees. But the details have not been given.
But have you taken or not for the purpose of selling the property?
My lord, 8 lakhs rupees. My lord, our defense is that we have not taken, my lord.
Then this is there.
And it is, my lord, if there is an agreement, even the allegations are, my lord, prima facie taken to be true on its face value, then he can, my lord, execute. He can also, my lord.
You are at best, your case is a plea of alibi. Plea of alibi has to be proved on trial only.
But the entire allegation was against the accused number 1, my lord.
That's right.
That my husband.
See, the paragraph which you have read,
my lord,
you also accompanied your husband. Accused persons.
No, your lordship, the agreement was, my lord, the previous page, my lord, page 16. Paragraph 2 and 3. The accused number 1 in the month of January 2007 induced the complaint that he wants to absolute sell the aforesaid property in consideration of price rupees 8 lakh.
How much you have taken, you tell me?
My lord?
How much, what is the amount of consideration you have taken from them?
My lord, but no amount has been taken, my lord.
But you wanted to sell the property without money.
Well, without money, he did not give the money and now threatened us, my lord.
No. Where is the agreement to sell? Show me.
But agreement is not there.
Give me the agreement. Show me the agreement.
Lord, agreement is not there with me, my lord.
Show me the agreement. In the agreement, there will be consideration. How much they have paid in advance, that will be written there. Show me that.
My lord, that I will file, my lord. I will file
that is all. If you have taken money, pay it. Your husband has died out of cancer. You have taken money to sell a piece of land. You are not paying the money which you have taken. May not be 8 lakhs. Might be something less. I don't know. Show me the agreement. And pay the money, I'll pass it. As simple as that.
My lord, your lordship may kindly fix up to next week. I will take the instruction, file the agreement. And
it must be there in your file.
No, my lord. Had that is in there, my lord, I would have given.
Check it up. It must be there.
List of citations I have given that
it must be there. It will be very inconvenient document. Therefore, you have not filed.
No, I will file, my lord. Even if
just check it. If it is there, I just
there is a power of
allow your petition right now. I allow your petition. Just let us see the agreement you have.
And agreement actually I do not have. But next week I will file, my lord. I never, my lord, say.
That's the only thing. You show me the agreement. If in the agreement, if you have agreed, you have taken some money, you have to return it. If you don't have money, we will think of fixing installment or something, and pay it and finish it up.
My lord, I will take instruction. How much?
Because your husband has entered into an agreement.
My lord.
Taken the money.
My lord.
When he the land could not be transferred, he came and asked you the money back. Both of you scolded. That's the allegation.
Allegation, my lord.
The fact of the matter is, if money has been taken, some transaction has taken place. The land cannot be given because your husband has died. So the money, whatever money you have taken, you pay it back. As simple as that.
My lord, I will take instruction from the petitioner number 2. But your lordship, with great respect, my lord, even if there is an agreement or contract for the sale, it can be executed in the civil code. I am bound to, the successor also are also bound to sell the land if the agreement is proved.
But you don't want to pay him back money. And he'll keep on fighting, file a specific suit and keep on fighting. Thereafter, run around you for, after taking a decree for execution. That's what you want. And your children will be also now the dependents in that suit. Because husband has died, children has to be dependent in the suit.
My lord, we have become victims.
Why are you creating problem for yourself? Shall I dismiss it and face the trial?
I will take instruction, my lord. But that is the court and thrust of the...
Then the paragraph which you read, on that basis, a case is made out. Prima facie case is made out. Rightly cognizance is taken. I will not interfere. As simple as that.
I will take instruction, my lord. How much
that's a better idea.
You will be able to pay.
Take it and finish up.
My lord. Next week, any date, my lord, I will take instruction and...
Don't hide behind the technicality. come to the reality. What is the dispute? Dispute is you have taken money, you have not registered the land for any reason, because your husband may be cancer patient, he died for any reason. Now you have taken money, you pay it back. Why are you hiding behind technicality? File a suit, I will not pay, all these things will not work. Not work. You pay it. And you tell me how much you have taken. That's all.
Next week, I will take instruction and
simply adjourn, interim order to continue next week, and you tell me.
No. Interim order is not there, madam.
No.
Interim order is not there.
Okay. Tell me next week you pay, and I'll send it to mediation and pay and finish up. Yes.
If she is agreed, you can pay also at the lower court also, check amount, anything.
Whatever.
Correct.
Item 51, my lord.
Yes.
That complainant is on virtual mode, my lord.
I'm here, sir.
I have already dictated.
Yes.
Dictate कर दीजिए. ठीक है. ठीक है. जितेश महापात्र. 1 minute.
Sir, I'm here, sir.
ଆପଣ କେସ୍ କରିବାକୁ ଚାହୁଁନାହାନ୍ତି?
ନାଇଁ sir.
କରିଦେଲେ?
Sir.
ହେଇଗଲା?
No, sir.
ହେଇଗଲା? କିଛି ପ୍ରୋବ୍ଲେମ ନାହିଁ?
Sir.
କେସ୍ ଖତମ କରିଦେବା ନା ଚାଲିବ?
ନାଇଁ sir, ସରେଇ ଦେବା sir.
अच्छा ठीक है. Okay. Yes. Aadhaar card, give the Aadhaar card.
Okay. Well, I will
get. Next.
55.
Request. Yes.
Next week.
56.
May I please your lordship? Here, your lordship, I will notice you are served by the opposite party and they appeared.
Yes.
My lord, kindly peruse.
Is paying for costing of cognizance. Is of year 2024, January 24.
What are the allegations?
And charge has not been framed. So let him ask that point at the time of charge, my lord. Why?
No. Why? Please wait.
Oh, yes,
I am the petitioner. I have to say first.
Yes.
My lord, kindly peruse. Annex 3, your lordship.
Annex
3. That is under challenge. This is the cognizance order. My lord, coming to the case, your lordship. My lord, kindly peruse Annexure 1.
Shall I look at 3 or 1?
3 ta challenge hochi. Mu pray kurchi
1.
1, my lord.
Yes.
This is the FIR. It was lodged on dated.
Yes.
13/8/2023 by petition number 6, your lordship. My lord, kindly peruse Annexure 4 thereafter.
Yes. Yes.
1 minute. Sorry, my lord. Here, your lordship, kindly peruse the date of presentation of the 160 case before the landed court below.
Yes.
That is on dated 5/10/2023, that under seal, your lordship. My lord, now I am placing before your lordship why this case was filed against me. My lord, as per Annexure 1, your lordship, on 13/8/2023, there was a dispute between the parties and they assaulted petition number 6, and petition number 6 lodged an FIR before the Salipur police station, and case was registered and charge sheet was submitted by the police against the opposite party number 2 and others. Thereafter, my lord, after lapse of 2 months, this 160 case was registered on the same cause of action, your lordship. They simply stated, my lord, on 13th.
Yes.
Cause of action, my lord, I am placing.
Yes.
Date of occurrence. My lord, kindly page 38, your lordship, Annexure 4, para 3, and date of occurrence I am placing, your lordship.
Yes.
13/8/23 at about 9 AM. This was lodged, FIR was lodged on same day, and after lapse of 2 months on the same cause of action, this case was initiated against me. Thereafter, my lord, my second plea that opposite party number
1 and 5. One is the at present working as SI of the wireless department of
What are the allegations here?
allegation here, same allegation.
This complaint case you want quashing.
To quash, my lord.
Okay, let us see what are the allegations.
My lord. The fact now come to the fact of the case, your lordship. There was a civil dispute is pending between the parties, your lordship, for a piece of land. And opposite party, number 2, along with some other henchmen, trying to dispose the petitioners, and they file several cases against it. I am also demarcated 144, file a 144 CRPC, some other proceeding, your lordship, that was already dropped. Now, your lordship, on the day of occurrence, on 13/8/2023, after the demarcation, my lord, after filing the demarcation petition, I demarcated the land through a government domain, and some fences were
But all these things are all right, but you see from the complaint,
my lord,
whether any case is made out or not, that is the test.
Yes, sir. That is the
See the complaint.
My lord.
At page 40.
Page 40.
The allegations are very specific. Allegations are very specific. Where are the statement recorded? Where is the statement?
Learned magistrate.
202?
202, 200.
Where is
complaint
that? Where is that?
Not
statement?
given. Yes.
I have not applied.
Let us see the 202 statement.
Yes,
Whether
my
the
lord.
case is made out.
Complainant and
And maybe it is a counterblast, whatever. That will be tested some.
But here, your lordship, I have a second plea, I have taken, your lordship, plea of LEB, your lordship. Because I have opposite party, petition number 1 is the ASI. At the time of occurrence, he was in duty. Professional duty, I will engage annexed, your lordship.
What is the real dispute?
Real dispute is for land, your lordship.
Which land?
I have purchased the land, 2 separate cell deeds.
I have means which petitioner?
Petition number 1 and his father, your lordship. Petitioners, all the petitioners.
All the petitioner purchase the land?
Purchase the land.
Yes.
And the opposite party number 2 and others. They are saying that this particular land belongs to, lead to the Ma Parvati temple, and he cannot purchase the particular land.
Who is the opposite party number 2? Who is she?
She is one of the.
They say that the land
belongs to
a temple.
Public, and you have no right at all. For the reason I demarcated the land, according to the punch was conducted, but they have not denied to, they are not admitted with.
Any civil proceeding is pending?
Yeah, 2 civil proceedings pending.
Pending, who has filed it? Who is?
I filed.
You filed it
Yes,
for declaration?
Yes, your lordship.
And what about the?
Now it is pending.
Who all are the defendant in that suit?
Yes, I have annexed, your lordship, annexed 2.
2?
Annexed 2 alerts.
That is written statement you filed. Where is the plaint?
What is the statement?
Where is the plaint?
Plaint is also, both the plaint file karne. I will file, my lord.
You filed all these things.
My question is
criminal liability, my lord.
Is there any chance of settlement?
One case is pending against us. So, if
one case is pending against you.
Yes, my lord.
One case is pending against them.
Yes, my lord.
Civil suit is pending. If it is the property of a temple, that will be decided.
It's a common passage for the villagers, my lord.
Who are you?
I'm one of the villager. And incident occurred. That's why I filed the complaint case 354, 379. All these.
You are public spirited.
No, my lord, not public.
Because you are also eyeing on that same land.
I'm the victim, my lord. I'm the victim.
But the false case they were initiated against me.
Is there any chance of settlement?
I will take instruction, but I don't have instruction.
But you are, I'm a police officer.
I will take instruction. The case against
You are a police officer, therefore the whole problem.
Yes, ma'am.
No,
that is the whole problem.
You are a police officer doesn't mean that you will take away the land of the temple.
I will file all the.
And you want to prevail, you want to throw your weight on them. They are villagers. They say that public land, how can you take? You might be a police officer.
My lord, I will honorable court needs the documents and all the plans. Then I will.
That's right, but I am just exploring the possibility of a settlement. If possible, do it. It is public land and you people are fighting.
I am ready. As per the punch. They may call for the punch in the court also.
And the statement, the complaint statement and 202 witnesses. That may be
produced. 1 week time to record additional document to substantiate the case. Let him do so within a week. This is the matter.
No, 70 for the absent roles. 70 for actually. after 7 days. That interim order to be corrected.
interim order नहीं charge frame है पर
Entry order, see, charge frame होगला, एग्रावेट होगला, settlement वाला होगी जो, settlement करो, खत्म. I'll send it to mediation. You seek instruction whether settlement is possible or not. The case he has registered against you will be quashed.
Yes, ma'am.
And the case you have registered against them will quashed. And the in the civil suit, it will be decided whose land is that.
Yes.
At least you get out of these criminal cases.
Yes, ma'am.
And insofar as the civil case is concerned, the rights will be decided there. Okay. Okay. Yes, sir. 9.
I'm for the respondent, your lordship, I'm for the informed.
The last time service was complete, but nobody appeared.
Yeah,
Now,
okay, I'm
he's
okay.
appearing and seeking an adjournment. Huh?
Yeah.
So entered appearance for opposite party number 2 and seeking adjournment to file response to the petition. Let him do so within a week. Release the matter after so. Yes.
After 15th, your lordship, I have.
Yes, after 15. Yes.
Grateful, your lordship.
Item 16.
Lorships, I have entered appearance yesterday for opposite party number 2, but my name has not been reflected in the cause list. Lordships, I don't have any objection also. If your lordships will direct, the opposite party will appear personally also.
Hey, what is this matter?
It's a case and counter case, your lordship. I am the accused person in the counter case, your lordship.
The 2 matters are there?
My lord.
Which one?
No, one matter is there.
The other matter? Counter case?
Counter case, I'm filing the FIR, not
2 FIRs.
2 FIR is lordship.
You are seeking quashing of the one FIR. What about the other FIR?
I don't know, I don't mind.
I have been instructions, your lordships. I have not received the.
Have you settled the dispute?
My lord.
Have you settled the dispute?
No, your lordship. I am just filing the quashing of the convenience order after.
He says she doesn't have an objection. For quashing, you don't have an objection.
No, lordships. The opposite party number 2 will appear personally if your lordships direct.
Then
my lord.
Settlement.
My lord.
And file another petition.
Yes,
in so far as the cross case is concerned.
Instructions.
Get it tagged so that both the cases can be quashed.
My lord.
So entered appearance and submits that for opposite party and submits that there is a settlement. The parties have arrived at a settlement. Accordingly, she seeks an adjournment so that she can file a separate petition for quashing of the FIR, cross FIR number. Oh,
cross FIR number, my lord. I am the accused in the FIR number 74 of Mahanda.
I am asking about cross FIR.
73 of Mahanda case number 73 of 2020 orders.
Filed by her.
No,
filed against her.
Filed against.
Against me.
Filed against them.
Okay. PS case Mahanga PS case number 73 of 2024.
2020 orders.
2024.
2020, I think they have wrongly mentioned.
24 you written.
20, sorry, my lord, wrong news.
2020, yeah. 2020. Huh? Lease the matter. When can you do that, madam?
2 weeks time. 2 weeks after.
Lease up 2 weeks. File and along with that, huh? Once.
Mala interim to contact.
Interim.
It's a matter of release of vehicle involving the excise case, Lord 7172 J bar, where your lordship judgment is covered by this. And last occasion, lordship directed the state council to verify the judgment passed by your lordship.
Confiscation.
I have given.
Confiscated over my lord. Auction has been placed. And your lordship knows there is a bar.
Oh, there is no bar.
No, that's right. For interim jima, there is no bar.
Yes.
But if confiscation proceeding is concluded, what will do? Where is the question of interim jima?
By the LDA.
Where is that confiscation?
Report
Yes, already a confiscated offer.
If there is a confiscation,
and also he is not guiding the authority.
Huh?
Although notice has been issued to him, he is not appearing.
But there is a confiscation order now.
Already over confiscation.
Where is that order?
Without appearance, completion,
That is the note of some.
proceeding over.
You are not cooperating there. Neither you are appearing.
That is their report. On 27th, they have sent the notice.
Neither Subhakan Behera nor his lawyer.
Where are you reading, sir?
Last one, paragraph 2, page 2, last 3 lines. That instead of filing objection, they prayed for extension of more 15 days. Last 5 lines. Page 2, your lordship.
Yes.
I am reading fast. That the authorized officer on going
15 days also authorized officer denied and
allow 7 days more time to filing Mokaladama before
date of
20. Instead of filing their objection, they prayed for extension of more than 15 days. But the authorized officer denied to consider his appeal on 30/11 because there was a war on limitation. Within 30 days, they have to file. Thereafter, my lord, the date of auction on 10/1/2025, the seized vehicle was informed through telephonic conversation to Subhakan Behera, the present petitioner, and his lawyer and advocate. That the date of auction.
When the confiscation order was passed?
My lord?
Confiscation order.
Your lordship, kindly have already MBA. There is no appeal here, my lord. Paragraph 1. Page 1, your lordship.
Yes.
That a shokoj was issued in favor of the accused and the owner, vehicle Subhakan Behera, by such and such, for submission of appeal before the after appeal is to file before the competent authority. Neither is thereafter, my lord, the vehicle has been, my lord, already here, my lord, that the MBA Puri has pleased to affix the offset price of the seized vehicle 2,80,000. As because he is not cooperating, my lord.
You can't done anything.
A copy may be served below. I have to verify because to my instruction, notice served on 27th.
No. Notice was 17/12/2024. Notice was you have annexed the report is there, confiscation report, flag B. And thereafter confiscation is concluded and put to auction. And
it has been put to auction.
Auction.
Yes.
And no bidder has come.
Yes.
And it was informed to your client and your lawyer. Nobody has gone there. Therefore, it was put to see the first option was given to you. You didn't go. And your lawyer also put to notice he didn't go. Therefore, it was put to auction on 10/1/2025. No bidder came forward. Second auction will be done now. Yes. What to do with this is?
With that,
I'll dispute it up.
With that objection, as per the instruction, your lordship.
Pursuant to the order dated 20/1/2025, Mr. Karnal and Council for the State has placed on record a written instruction dated 22/1/2025 received from District Excise Officer, which reads operating part of which reads agenda. पूरा that को लिख दिया इस वजह so the instruction from the aforementioned instruction, it is clear that the confiscation proceeding has already been concluded and the vehicle in subject has been put to auction on 10/1/2025. Since no bidder came forward in the auction process, the bid was the auction was not successful. In the view of the aforementioned development, nothing survives in the present matter. Accordingly, the same disposal, liberty granted to the petitioner to resort to other remedy. All other remedy,
75 also compounding.
all other remedy available
He can
to
also
him.
have healthy vehicle.
All other remedy available to him under law. Under law. Nobody will come forward for option. A vehicle who will come and you pay. Therefore, they called you. You would have paid and taken.
Now, if that is the status of the case, then
you can't help it because there is no question of interim jima. Interim jima pending confiscation. It's concluded.
Yes.
What to do?
Even at the stage of appeal, that is
75 compounding we are.
चलो सरलाई देते हो कौन
हाँ चलो
My lord, order of cognizance and entire criminal proceeding under challenge matter. The petitioner number 1 is the husband of the opposite party number 2. And the petitioner number 2 to 5 are in-laws of opposite party number 2. In both the petitioner number 1 and opposite party number 2, husband and wife, are IT professionals. And the marriage between them has already dissolved, has been dissolved.
You are appearing for?
My lord, I am appearing for OP number 2, the informant in the FIR. I had day before yesterday on Monday, I had submitted before your lordship that we have no objection if the FIR and all the criminal proceeding that stems from the FIR is quashed. My lord had directed me to file for a no objection affidavit, which I filed today. And I pray before my lord keep their prayer for questioning of the FIR. If it is directed, then we have no objection. We have all moved on with our lives. We do not want to interfere anymore.
Yes, my lordship. Musical divorce allowed. Yes, my lordship. On 23rd to 2022. 13B was allowed.
But they should have been. They should have appeared.
Yes, and filed affidavit.
Can they appear at least the informant?
Where is the informant staying? I am on our.
No, please appear.
If my lord directs for a
Online appear tomorrow.
Tomorrow, my lord, I'll.
Where is she staying?
She's staying. She works in Bangalore, but she's right now at home for her sister's wedding. So she's. So I'll tell her.
And appear through VC. I'll
okay, my lord,
just see and can it tomorrow?
Yes, ma'am.
Tomorrow. Okay. Give it tomorrow, please.
My lord, my lord.
Can the petitioner, my lord, appear on VC, my lord?
Yes, yes. Don't bring them here. Let them appear through VC.
Moment.
And when, at what time? Give them time so that they will not wait from morning.
At
12 o'clock? 2. Okay.
Second sitting, ma'am.
Okay.
When you are
2 o'clock. Let them.
2.
Or why don't you do it in the morning and finish up? They will be free.
My lord, it will be better if you do it in the first half and then.
That's better. So 10:30 morning, let them appear so that
my lord, my lord.
I'll take it as a first item.
My lord.
10:30.
May it please, Your Lordship. Item number 64, Your Lordship. Previously, Your Lordship heard this matter and issued notice to the opposite party. In item number 64, the opposite party's counsel also appearing through VC, if I am not wrong.
Yes.
He left, my lord. Your Lordship, what happened in this matter, my lord, they filed a case, including the offences of SC/ST. Finally, the charge sheet submitted 294 and some 31R of the SC/ST POA Act, Your Lordship. I have the case for passing out to proceedings, but Your Lordship directed to.
Number of civil proceedings are pending, my lord. In that case, man. Out of civil dispute, the case has been first.
If a
Earlier
mediation,
also in the year of 2009, they have the informant family members also lost the case, and that has been FIT, my lord. False has been proved, my lord, by the IO, my lord. Subsequently, civil dispute is going on. Subsequently, my lord, the present case is first led. On that basis, my lord, I have
Each case has been initiated by them, and case and counter case. 3 or 4 civil cases are there, and for a single piece of land, and and 4 criminal cases is there.
Number of cases, man.
That belongs to accused party, Your Lordship. It is a civil proceeding, my lord. They initiated criminal angle.
It's all right. How many cases you have initiated against them?
No
One.
criminal case, Your Lordship. No single criminal
Not
case,
initiated.
but civil case. They occupied my land.
Forget about civil case. How many criminal cases you have?
No criminal case. No criminal case.
Kindly have a glance to page number 5.
She says 8 cases.
Yes, my lordship, kindly have a glance to page number 5 of that petition.
5. Yes.
in the paragraph 6, it is relevant to submit here that in the year 2005, one criminal miscase number 53 of 2004 under section 144 CRPC was initiated. And in para
144 CRPC is not criminal case.
Oh, it's all right. Quasi-criminal maybe.
In
Yeah.
para 7 also, they have written, my lordship, one of the family members of the present informant family also lost a FIR during Paradip Law PS case number 106 of 2009 under section 436 to 94 506.
These cases are there.
SCST. My lordship, in page 6 also, in para 8 they have mentioned, para 9 they have mentioned, para also there.
The complainant side filed, my lord.
Huh?
The complainant side filed. The complainant's family members filed cases against us.
That has been
Police
FIT, my
also
lord.
specifically. Police
Anyway,
also
cross cases are there.
Yes.
My lord,
So,
your lordship,
what do you want? Do you want to fight it out or settle?
for the settlement of only, my lord, your lordship issue notice. Your lordship may kindly fix a date so that the opposite party may come and the date may be fixed for mediation.
What do you say?
My lord, I'm also happy with petition, my lord.
We are
I thought you're opposing it. Okay. Then who is appearing for the opposite party then?
One Samantra is online, my lord. He is appearing through online.
Where is he?
Mr. Samantra.
Narayan Samantra.
Anugraha Samantra.
Anugraha Samantra.
He is appearing.
Why you are not keeping it open? Every time it is closed. Are you keeping it open or not? Why are you not keeping it open? Yes, Mr. Samantrai, what do you say?
You'll also fix another date so that he will appear physically. I will contact you.
No, it's very difficult. Simply adjust entry mode to continue.
Grateful.
Grateful.
So no compromise.
No compromise, that is.
Okay.
Yes, ma'am. Taken up one chapter, my lord.
65.
Yes.
Thank you, petitioner, my lord.
for the
Notice served, ma'am. Last occasion, notice served, ma'am.
That's why I'm entered appearance for the sole opposite party.
Okay.
Yes, your lordship, if you permit me, I will place my case.
Are you ready, madam?
My lord, 2 weeks time to file affidavit, madam.
What affidavit? Lordship, they have filed the case, and what affidavit they are saying to file?
He is not ready.
Okay.
So and so entered appearance for opposite party. And forward by will counsel for the petition seeking adjournment to the court to make the hearing, release the matter.
Lordship, is there any increment or no increment?
I is there, my lord.
There is no entry.
I is there, my lord. First is.
No increment is there, Lordship.
No entry model.
Yes.
Next. 66. Huh?
My lord, 66 item.
There is a mention.
My lord, item 66, my lord.
66, Mr. Das has some problem. It will remain in the board. Will see.
At least some adjournment. Tomorrow is the date for pending of charge. At least some order for the adjournment can be obliged.
There is no order. As such. You have challenged what? What have you challenged?
Discharge petition against the discharge order passed by this 11th special judge. Vigilance.
Being the discharge case, what will happen? If you charge this frame also, I can quash it. No problem. We shall take up. I think next week I'll start taking.